everyone. Welcome back to the Wyoming Blockchain Task Force. We've got another excellent day ahead of us. We know that the hackathon is starting up in earnest today as well, so hopefully, I know that part of the reason why there aren't so many people here as there were yesterday is because they're over there engaged in the opening of that, and I expect a lot of people to be coming back and forth depending on which topics for consideration of today. We do have an important agenda today, though, so I hope everyone, as you're going back and forth, will take a look at when we're going to be considering some of these topics so that you can provide us with some extra testimony that you have the opportunity to do so. I'll remind those that weren't here yesterday of our protocol. We do invite public testimony after every topic, and we encourage that public testimony because we want to hear feedback from the community, the stakeholders, and the experts. It helps to shape our product, and it's an important part of the reason why we've had a good product the last few years is the feedback that we receive from the community. In fact, I wouldn't even call it feedback. It's pretty much the basis for all the things that we're doing is what we're hearing from the community. So we welcome that. But when you do come up, please introduce yourself, state who you work with or work for, and then work through the chairman, which will be either me or Tyler, to maintain the protocol, and we'll certainly invite all of that to the public comment before we work legislation, before we move anything forward. Mr. Co-Chairman, anything that we need to do before we get going with the agenda? Any comments you'd like to make? All right. Committee. Opening up the committee. Preliminary comments? No. Also, anything we need to go over before we start? Seeing none. All right. The first agenda item for our consideration today is digital speech protection and immunity. We spent a little bit of time working on this at the last meeting we shared it. We've got a new draft, and this is 20/55 version 6. Incidentally, if you haven't already got copies of these drafts and you want a paper copy, those are available over to our left on the table. They're also available digitally online. One thing I did forget to state about logistics today is this is being live streamed. So remember that when you're making public comment, that's going to be preserved and live streamed, and give some consideration based on that when you do make your comments. All right, with that, let's go to digital speech protection and immunity. And is it Tamara that's going to walk through this, or me today?
That'll be me, Mr. Chairman.
Great.
So for your background, this was a bill that was before you, the task force, in August. And at that time, the task force appointed a working group. On that working group were Senator Nethercott, Representative Yin, Ms. Long, and Mr. Cole. We got together via conference call between the last meeting and now, and worked on some revisions to the bill. And so the revised bill took out some of the provisions, so you have a shorter bill in front of you, and specifically what was taken out was there was a broad statement about digital speech being treated as any other form of speech. That was removed. There was also a provision about state funds being used to compel the alteration of the digital expression, and that was removed. Also, provisions related to civil liability were removed from the bill. So what we're left with is a bill that relates to liability of computer programmers and hosts in Wyoming for the actions of a third party, of another person. And we've also revised the definitions to be a little bit more useful for what we're trying to get at. So the first change from what you saw in our meeting comes on page 2. Digital expression is revised to now mean an expression that is communicated through source code or a computer program. It used to be an expression of speech, and so that's just revised to indicate it's not just speech, it's just an expression that is communicated through source code or a computer program. On page 3, the definition of source code has been refined. Source code now means any form of work used to create or modify a computer program, and it specifically includes instructions and statements expressed in a computer program, computer programming comments, notes, and memoranda, and design documents and functional specifications for a computer program. The need of the bill is on page 4, lines 7 through 20, and this is really what it does, is that it specifies there shall be no liability for digital expression that does not otherwise constitute a crime or subject the person responsible for digital expression to criminal liability. That alone shall not serve as the sole basis for any criminal liability based on the use of the digital expression by another person to the end user or a third party, someone else. And in subsection B, hosting or storing digital expression on a computer network, computer system in Wyoming that does not otherwise constitute a crime or subject the person hosting or storing the digital expression to criminal liability shall again not serve as the sole basis for any criminal liability based on use of that digital expression by a third party, another person. There's a clause that is not changed, finally, that just says that this article shall not be construed to prohibit liability for actual criminal action. And it would be effective July 1st, 2020.
Great, thank you, Tamara. Committee, any questions? Questions? Discussion. Ms. Long.
Thank you, Mr. Chairman. Just a comment about the group's work. We did gut the problematic or the more challenging parts of this bill, the free speech and the civil liability parts, and left with what was frankly the real important part, which is that a developer, which is what we were really after, which is that a developer cannot be held criminally liable merely for writing code. In our side working group, we had conversations about the malicious open source code writer who deliberately puts some sort of a backdoor or malicious piece of code into open source software. And in the large open source projects like Linux or Bitcoin, it's unlikely that something would get through because someone would find it, but in the smaller open source projects, it may be more likely. And the thought is that there's still plenty of opportunity for Wyoming to pursue criminal liability to somebody who deliberately does put a backdoor in that causes, theft of cryptocurrencies, for example. And so this is essentially saying that they cannot be made liable merely for writing the code, but when someone goes and uses the code maliciously, of course there are all kinds of crimes that they can be charged with. So I think we landed in the right place. We started much broader, but this is much more narrow and frankly gets to what we really wanted to do.
Great, thank you, Ms. Long. Any further discussion? Mr. Co-Chairman.
Thank you, Mr. Chairman. I don't want to kind of force testimony out of people. We do have two people on the task force that are, this would directly affect as far as what they do for a livelihood. So I could get Representative Ian or Mr. Cole to testify to that.
Let's do that then. Representative Ian, what are your thoughts on the balance that we struck with this track?
Yeah, thank you, Mr. Chairman. I think that overall it's pretty good, and it definitely makes it so if someone who is a programmer writes something that is illegal, they are still liable for criminal liabilities. At the same time, if they write something, for example, like Bitcoin, which has actual uses that are not criminal, that they wouldn't be liable if a criminal uses it for criminal purposes. So I think that it feels right to me, especially the source code program part, where it covers basically everything that the programmer wrote. So I think I feel good about it.
Excellent. Mr. Cole, what are your thoughts?
I agree. Nothing to add, really. The sole basis part of it is great. Oh, sorry.
You can run the mic.
I was just going to yell.
Yelling sometimes works.
Okay. No, I don't have anything to add from Representative Ian. I feel good about it.
Excellent. One thing it looks good. If we have end up with any concerns, are we comfortable with the definition of source code? Those are always challenging. We all know what source code is when we hear it and when we see it, but getting it right in statute, did you do a good job? Any thoughts on that?
Mr. Chairman, I would have a question in regards to how it reads and how it places in statute for maybe the chairman of Judiciary, because most likely this will be going to her committee, and I'd like her thought, because I think she's prosecuted in some
I was on the phone calls to really refocus this bill and rein it in a bit. Whereas I don't fully appreciate some of the concerns that have been presented to justify the bill based on other laws and broader concepts associated with free speech. I do think that this addresses those concerns, that's narrowly tailored enough, that could pass muster. And so that's what we're here to do. So I'm satisfied with the bill. I think it'll probably get pushback from some others, but we'll deal with that at the time.
Excellent. Some pushback, if that works. Anyone else, maybe, before we go to public testimony? Any other thoughts and comments? All right. Seeing none, let's open up for public comments. Would anyone like to provide public testimony? Please come on up. Welcome. As always, state your name and who you're with.
John Rumpus, co-chair of Wyoming Task Force. Thank you very much. This is Evan James, co-founder of Alexandria Labs, a Wyoming LLC founded earlier this year. I was eager to come speak on this, but truth is, as soon as I read it, I didn't really need to very much, just because it's so short and to the point. And I just wanted to say that we eagerly support it. I like to use the analogy of bolt cutters. I'm talking about this kind of stuff, and this kind of gets into that perfectly, where the tool is a very legitimate tool, just like something like BitTorrent, even though it's perceived by many to be just to enable illegal activity. And I think that's especially important right now, because what was different about BitTorrent was it had no central points of failure, thus no central points of leverage. And the more decentralized technology comes into the world, the more we're going to see things like that. And some folks are going to be tempted to call something illegal, where in fact the source code should not be. I do have one question. That it does seem that it's the First Amendment that enables most of the things that digital data would be resulted as being called free speech and being called legal, where some people might assume that maybe it shouldn't. So I wonder why the language about free speech was removed. Was it just redundant, or?
Thank you, Mr. James. Did anyone address that? Anyone interested in addressing that? I know that was a theme of the working group. Senator Nethercott, to you.
So do I understand why the language concerning free speech was removed? Is that the question?
Yeah.
So if you look at statutes, I mean, every type of communication is a speech. It could be considered under a First Amendment analysis, yet in our laws we don't delineate all types of speech and communication. So we don't say writing books is protected under the First Amendment. There's no need to do that. That's not how the Constitution applies. And so by carving out separate sections, you actually might be having an opposite effect of creating an absurd result in the law where only digital speech is protected and none other, because we have put a higher priority in statute for digital speech as opposed to books.
Thank you, totally makes sense. Thank you.
Thank you, Senator Nethercott.
Mr. Chairman?
Yes, Ms. Long, go ahead.
Yes, and may I just add, I don't think that this reduces the effectiveness of the bill. The real point of the bill is to make sure that developers don't have criminal liability for contributing to open source projects. And they absolutely still have free speech. You do. And to Senator Nethercott's point, it just would have mucked it up. And we just cut to the point. And we have a lot of conversation about Cody Wilson. And there were a lot of concerns about developers writing code that some folks object to the use of. But what we really wanted to distinguish is that the use of the code is where there may be criminal liability. It's not writing the code, and I think we accomplished that.
For clarity, when you mention Cody Wilson, do you mean, because what occurred to me is this also kind of comes into the manufacturing, the physical manufacturing that he was also involved in. Do you know what I'm referring to?
Ms. Long, go ahead. And we're through the chair. Don't forget to go with protocol.
Thank you, Chair.
Yes, Mr. Chairman, yeah.
Anything else?
No, thank you, sir.
Thank you. Will you join us? And once again, introduce yourself and who you're with. There's a little, yeah. Right at the top.
go. Hello, Mr. Chairman. So my name is Robert Benke. I am the CEO and co-founder of a platform called NewGit. NewGit is a very newly formed Wyoming C Corp. All right. I want to thank everyone's work. I think that's what brought us to Wyoming. So, NewGit's primary focus is solving a fundamental problem in open source, which is that developers primarily don't have incentives to get paid to develop open source. So I wanted to come up here and say that from everything that I've read on this bill, that we're for it. One thing to consider, whether it's on this version or a later version, would be to consider any of the open source licenses and what that might, what might happen with this law being passed, and how that might deal with certain open source licenses like the MIT license. I just wanted to say that I'm also in full agreement that it comes down to intent of what you're doing. In a lot of ways, code and source code is the same as writing poetry. It's the same as using an instrument. It's the same as using a computer. It can be used for good. It can be used for bad. And ultimately, I think that after reading through this, that there are a lot of opportunities to actually bring jobs into Wyoming simply because of this. I think a lot of people are probably aware of those considerations. That's it. That's all I just want to say. We're really for it. And thanks for everyone's work.
Thank you, Mr. Benke. How do you spell your name?
It's B-E-H-N-K-E. Thank you.
I think
Mr. Chairman.
some questions. Mr. Coach,
Yeah, thank you, Mr. Chairman. And just as a reminder for everybody, if you do testify, make sure to sign in the sign-in sheet. That way our staff has your name and we can forever know who you are and where you're from. Like forever, not pretend.
You're actually right into the blockchain.
We do. No, I appreciate it. Thank you, sir.
Any questions? I actually have a couple. No, seeing none. First is you mentioned a concern with regard to what type of license or license type. And as I see this, it's written license neutral, so to speak. That I don't feel like it has any concern for whether if you're using an MIT license or another open source license or even an unlicensed proprietary, this should cover it. So can you clarify what your concerns were with regard to licensing?
Absolutely. Not so much a concern, consideration. I have not gone over with legal counsel this thought. I was given this, made aware of this opportunity to present my thoughts just recently. So.
Excellent. Well, Mr. Benke, do that. Check it out and see if you see anything. Please get back to us if we have some considerations that should be brought in, specifically regarding licensing. And then the next question I have is a little bit broader, but you're going to be focused on development work in Wyoming and a development ecosystem in Wyoming. So the question I would ask you, and you don't have to have an answer now, but maybe get back to us, is this is one thing that we understand the development community wants to see, and so this was obviously together to support a development environment in Wyoming. Is there anything else along similar lines where best practices of other states and other localities are not already being implemented in Wyoming? And you may have examples at this point, or you may just give that some thought. Basically, do you have any other ideas on what governance structure helps to support a strong computer development program ecosystem?
There's certainly a lot there. Given this opportunity to come back and testify to address exactly that, I'd love to do that. I definitely would love to think on that. Nothing comes to mind.
All right, no worries. Yeah, please do. Thank you, Mr. Benke.
Mr. Chairman,
Yeah, Ms. Wong.
may I add, and perhaps get a comment from you as well. If you recall how we started this whole bill, it was designed back in the Jackson meeting, I think it was Jackson,
we were figuring out whether we could recognize DAOs within the state of Wyoming, and instead of formally recognizing DAOs, which would be a new form of legal entity that has no human being associated with it, all the DAOs by definition are open source projects. So our intent with this very clearly was to take away criminal liability for DAOs in an attempt to attract the projects to come to Wyoming. Now, to your point, that doesn't solve the licensing, but the licensing really is more about copyright and more civil concepts than criminal concepts. Of course, it could come into some criminal concepts too, but we didn't want to interfere with that, and I don't think we did here. But I'd love your feedback on it, because it's not necessarily obvious that what we did here was aimed at trying to attract open source projects, but that would include DAOs.
Thank you, Ms. Long. Mr. Becky?
I think the good news there is, after reading this, and after being very recently made aware of this bill, it immediately all the dots were connected immediately in my mind. So I think amongst the crypto community, amongst the development community at large, they'll see this as extremely forward-thinking. I'm not totally sure if any other states have this in place right now. Right? So, I mean, this is just going to open the floodgates, and I couldn't be more happy to promote it, really, I think.
Great. Thank you, Mr. Becky. Any further questions for Mr. Becky? Seeing none, thank you, sir.
All right, thank you.
Welcome back today. Once again, state your name for the record.
Christopher Allen, watching comments. Mr. Chairman, task force members, thank you very much for bringing this particular topic forward. So first I want to address the base topic, which is the expression. It has been a chilling effect. I can speak specifically to the early Bitcoin core community, largely stayed pseudo-anonymous here even in the United States, out of concern of that their work, even though some of them weren't even necessarily holders of Bitcoin, they were just contributing to the source code and the security of the projects, might be interpreted as contributory infringement of some future thing. And that definitely, probably kept a number of people out of the community up until about 2014, when all of a sudden, VCs and other people started coming into the community, and the guess was, well, at this point in time, if somebody hasn't said this is contributory infringement or whatever, they're not going to. But that doesn't mean it's going to happen again. There's nothing that stops that from reemerging. There is another issue that is not covered here. The entire industry that you are promoting here relies on security. And under current anti-VRM laws, these are the same laws that prevent your tractor owners from fixing their own tractors. It is against the law to basically reverse engineer something that is considered to be copyright protected in some fashion. This is sometimes known as digital rights management. This is particularly problematic for security researchers because these techniques are often insecure, poorly reviewed, etc. And security researchers who try to investigate have been prosecuted, have been prohibited from coming into the United States if they're from outside the United States, from participating. The Electronic Frontier Foundation actually left the W3C in protest because the W3C did not endorse don't pursue security researchers policy request of their members. So this is a controversial area. It's an important area. We're not, as a security researcher, the fact that there are certain things I can't touch, including some of the things that are implied by your own requirements for what is best practices in a custody If you look at the document, you mentioned some FIPS types of standards in there. Quite a few of those FIPS things are not public, and a security researcher who tries to investigate is that good security or not can be prosecuted under the, I forget what the exact name of the law is.
Copyright Act?
So it's too late probably for this session to add something there. Also, that is of course a federal act, but like many of the other things that you have done here to make a statement, I would love to see you add to this in the future some statement to that act.
Any questions? Any discussion? It's a really interesting question of what we can do, because it does come back to the NCA, so which is really, it all comes back to protecting the distribution of movies. So the entire industry is now beholden to, I don't want anyone to steal my movie rights from this blockbuster that's about to release, and all of this industry now has to adhere to these, no reverse engineering, no testing, do anything that tries to look at that code, you violate federal law. But I'd ask if you know if any other state has taken any steps, or what steps might be available for a state to take, recognize it as federal law, that would be helpful.
I am aware that this has come up in other places, in particular in California and I believe Washington State. The right people to contact would be the Electronic Frontier Foundation. Even the ACLU has a stance on this. But I think the key thing, maybe to connect it back to this thing, is that researchers are not, stealing movies.
Right.
They're trying to help preserve the security of our systems that we rely on. And, so it's more of a, research on the expression rather than the actions. And, in my, similar to the language that you have here, I don't remember the exact words, but it's along the lines of shall not solely.
Right, exactly. Yeah, so the intent matters, and the intent in the NCA doesn't matter. Anything else? Ready? Seeing none? Thank you, Mr. Allen. All right, we are on 2055, Working Draft States Digital Expression Protection Act. Would anyone else like to provide public comment at this time? Anyone else? Going once, going twice? Gone. Public comment is closed. Back to committee consideration. Committee, what is your pleasure?
Move the bill.
We have a motion from Ms. Long. Is there a second?
Second.
We have a second from the co-chair. Any discussion? Any discussion?
I'd just like to, Mr. Chairman, I'd just like to add a big thanks to the folks that worked on this and got it right.
Agreed. Representative Ian.
Thank you, Mr. Chairman. I just want to make a comment that when it came to the discussion of source code in our conference call, I did reference a lot of source code licenses, trying to make sure that we aren't conflicting with those licenses in any way. I think we did a good job there.
Excellent. Thank you, Representative Ian. Committee, any further discussion? All right, let's go to the bill itself. Are there any amendments? We'll just open it up for general amendments. It's a short bill. Any amendments? Seeing none. Senator Nethercott, any thoughts or amendments before we go to a vote on 2055?
My only final comments are.
Okay.
So my only final comments are, I do anticipate receiving some type of pushback concerning carving out special speech protections as it relates to digital expression when there's no other carve-outs for any other type of speech. So it's just kind of that simple concept associated with that. Academia doesn't have protections associated with any concepts that are taught in higher education. So very important fundamental principles in this country associated with speech and communication of ideas. We don't carve those out for protection, and yet we're doing that for digital speech. And so there will be appropriate pushback, and I think the dialogue will be healthy and positive and appropriate. So so I want to make sure that those who care about this bill and are listening and stressing the importance of it understand kind of that larger picture. It's not that the detractors from it don't want to support this type of protection. It's just they don't want to carve out and elevating digital speech as opposed to all other forms.
Thank you, Senator Nethercott. Yes, Mr. Co-Chairman.
I just kind of echo Senator Nethercott's thoughts. She's not wrong, and there will be appropriate pushback. But that's based on the premise that really nobody's had this discussion or thought along those lines that this is a form of speech. And so I think it'll actually be a really good opportunity for education for a lot of the folks that will bring those questions, because for your average layman, your average legislator, having the conversation that code is speech will bring a lot of that to light. And I think it's appropriate. And then on top of that, when we're talking about your typical freedom of speech, whether it's with the press or academia or something like that, one aspect of that has that this does not is case law for years. I think that, anyways, it'll be interesting to see where this goes and how this shakes out. I think it'll be a good opportunity. Win or lose, it'll be a good opportunity to have that conversation.
Thank you, Mr. Co-Chairman. Any additional follow-up, committee? Yeah, I have similar thoughts. This shouldn't be a problem. We shouldn't need this bill. It should be clearly recognized as speech. It should be clearly protected, and it shouldn't be a problem. The trouble is, and the reason we bring the bill is because that hasn't been respected. We still have the DMCA, which should be recognized as a gross violation of freedom of speech. I can't crack the code, is what that says. I mean, if you crack this code, you have violated federal law. I don't know how that's a thing. I don't know how it hasn't been challenged and lost. But unfortunately, that still is a debate that's out there. I think what this legislation does is say that when it comes to Wyoming, we don't see it the same way that the feds do, and that we do see it as speech. So I agree with Senator Nethercott. This will be a robust debate. I wish this weren't a problem. I wish people respect speech a little bit more than they do. In fact, a lot more than they do. But we are where we are, so this at least kind of puts a stake in the ground for Wyoming. Committee, anyone else? All right. Let's call the question and have a roll call vote on 20 also, 55, working draft 6.
Mr. Chairman, before I take the roll call, I might ask if anything on the result of the roll call, though, whether I'd have your permission to work with you and the committee you send it to maybe find a better place within Wyoming statutes to put this code, just the section numbering itself.
Absolutely.
Overall, Senator Driscoll excused. Senator Nethercott.
Aye.
Representative Olson.
No.
Representative Yin.
Aye.
Mr. Cole.
Aye.
Mr. Kaufman.
Aye.
Ms. Long.
Aye.
Mr. Co-Chairman, Senator Rothfuss.
Aye.
Mr. Co-Chairman, Representative Lindholm.
Aye.
Mr. Chairman, that's been approved. Would you like to pick the committee you sent it to?
Thank you. I believe we're sending this one to your committee, aren't we? Judiciary? Are you going to speak on that?
It could go to corporations, Mr. Chairman. I heard they're friendly.
Yes,
All right. Let's send that to Judiciary Committee.
Mr. Chairman.
Yes.
I would like to note that Representative Olson is removed, and we're okay with
It was an awkward no vote, but he did take a stand. And did you understand the question?
I understood the question. It wasn't awkward for me. I think it was more awkward for the members who paused before their vote, knowing that they didn't want to cast the vote the way they did, but they still cast it.
I see. We just want to zing. Okay. All right. Right, exactly. It's all about emotions and feelings up here. All right. Well, thank you. Thank you for that clarification. All right. The next item for our consideration, I can find it on the agenda. Update on Joint Judiciary Committee's statutes work with Senator Nethercott. feel?
Well, Mr. Chairman.
Okay, let me give you this actually, so if you're speaking for
We,
an extended period of time, we should at least be able to hear and understand you.
so we have not met since our last blockchain task force, we as in the Judiciary Committee. But as indicated in the last meeting, in a discussion over how to deal with that of virtual currency and other types of concerns associated with the industry in the space, I indicated that the Judiciary Committee was looking at consolidating the theft crimes currently that have been in Wyoming statute for decades. So what you have in front of you is a bill draft of a working draft of that proposed legislation. It's not been approved, and it is under critical review right now with a number of members of a working group. But as I indicated before, you know, theft is a broad crime. If you take something that doesn't belong to you without permission, that's theft. It doesn't matter what it is. The value associated with it, though, determines whether or not it's a misdemeanor or a felony, is the typical association with that. So the meat of the bill and the meat of an understanding of a theft crime can be found on page 4, lines 16 through 20. And you can see there that I believe that definition encompasses any kind of virtual currency or any type of possessory interest that one may have over property that belongs to another. So it's my position that we don't need, and this committee does not need to try to solve that problem that's already addressed in Wyoming law under the definition of theft. So there you have it.
Thank you, Senator Nethercott. Any discussion, committee? Questions? Ms. Long?
Yes, no, I think this is great because by defining digital assets as property the way that we did last year, it should fit well within these definitions. So I would agree with Senator Nethercott. But one thing, I haven't actually read this bill, but I think it's worth talking about is the Supreme Court case on rehypothecation that defined pledging an asset that you've already pledged as collateral for a pre-existing loan to get a new loan was theft. It was interesting when I looked at that. It was President Perkins who directed me to that Supreme Court case, which I think was 1986. And since then, the theft statute the language in the theft statute had actually changed. And so it wasn't necessarily as clear as it was because it was rewritten in subsequent years. It wasn't as clear as it was, and that rehypothecation is theft. So just a general comment to make sure that to the extent that somebody is trying to sell something they don't own or pledge something they don't have a right to pledge, want to make sure that that's clearly covered, because that's a big part of what we're trying to do here is get honesty in financial institutions and solvency in the financial institutions. And I personally would love to see a state go after some of these practices on Wall Street that I think are actually illegal under state law. It's theft under state law, but nobody's actually challenged Wall Street on it yet. Thank you.
Senator.
Yeah, Mr. Chairman, if I may, and also just to provide some greater history as to why the Judiciary Committee is looking at this particular issue. There's been a number of high-profile cases in recent years dealing with theft and associated elected officials, particularly out of this county, that caused us to go back and try to rework these statutes. To address Ms. Long's concern on page 5, lines 1 through 3, that specifically addresses pledging of money or other items of value of property. And that's what's done. Even though the hypothecation and the financial services industry seems like it's a more sophisticated scenario, but pawn shops deal with this all the time every day. And so if we just go down and really make it more simple and understand what these crimes routinely are addressing as opposed to the more sophisticated version of the same crime, the law does address that.
Thank you, Senator Nethercott. When I'm looking at Roman 2 on lines 1 through 3, it's all of the property that's being referred to has to be known to be stolen. If you already have a pledged asset, that doesn't mean it's been stolen. So if I've got a house that's been mortgaged, and then I use it as the basis for mortgage for a second time, it wasn't stolen, everything's in order. And I don't know if that would, I guess the concern I have on Ms. Long's point is, how is the scenario where I take out 3 mortgages on my house going to meet that language in Romanet 2, lines 1 through 3?
Well, remember, Mr. Chairman, that there's an entire criminal code for which prosecutors can avail themselves of, and this is just one section of that dealing with that. So somebody who falsifies documents to get a loan, that would be another crime usually associated with fraud. And so that would be the crime that the individual would be charged with as opposed to theft. So a prosecutor, when presented with the fact scenario of what are the possible crimes that this individual committed, they evaluate all of those and then determine which is the most appropriate to go with. So in that case, it would not be theft, it would be fraud.
Thank you, Senator Nethercott. Any additional discussion on this point? Any other thoughts? Things that we need to consider? One thing that, as I read the kind of the new language, knowingly takes, obtains, procures, retains, or exercises control over. Exercising control over, how do you value, how is the valuation of that going to come into play? Is it the value of the thing you take control over, or the value lost due to the loss of temporary control? And I'll just say, I'll give an example, which is an extremely absurd example, but let's say I've locked down a simple file for a little while that isn't my file, so I preclude someone from accessing it, but it's a trivial file, no big deal. Maybe like a Word document with a poem in it. So I've definitely exercised control over it, but it's a bad poem. I wrote it. And maybe I've only locked down control of it for a day. So there's really no financial loss associated with it. But how do you value that circumstance?
Typically, it's done by valuing the object. So in the case of your scenario of a file and a poem, assuming that you're not around, author, poet,
And I'm not.
and you are not, that would be a misdemeanor crime. And so it would be a value below $1,000. But if by chance you were a famous poet and that poem might be worth more, then it could possibly be a felony, but I doubt it.
All right, anything else before we open public comment? Maybe you see none. All right. So we're opening up public comment on this discussion of the Joint Judiciary Committee's statutes work, and we have draft legislation that they will be considering at their next meeting. All right. Welcome, Mr. Allen. Once again, though, for the record, state your name.
Thank you. Christopher Allen, Washington Commons. Senator Nethercott? Yes. I wanted to, on page 5, section A, I wanted to bring to your attention and your committee's attention of A in the sense of we had this question last time about the theft of a private key, theft of secret, where it's really hard to say that you own the number 42. What makes it valuable is it's a secret, whatever the number happens to be, not that it's a number. So it's not a digital asset, but it can, in effect, deprive someone of their use or benefit. So one would be, do you believe that this sufficiently addresses the concern of this non-property thing that is used to control property? And is the word, adding the word control somehow in here to section A appropriate?
Senator Nethercott.
Thank you, Mr. Chairman. I do think that it does, but, you know, I want to urge caution that there's a number of layers involved here of how this particular crime would be charged. What do you have to have a prosecutor willing to charge that crime and the ability to successfully prosecute it to a jury that this person justifies going to prison or jail or receiving a felony, but that abstract concept of taking the pathway to the property away. I believe that it does, because by taking away the pathway, you are taking away the ability to access the property. So it's there. So I believe you're protected. But that will depend on each individual prosecutor and law enforcement's ability to effectively investigate that.
Thank you, Senator Nethercott. Follow-up, Mr. Allen.
Yeah, again, you know, my issue is this thing, okay? So this is a master key that can hold literally billions of private keys for an individual, that can hold everything from their personal assets, their personal identity information, all the way to shared information, things that I do with my board of directors in a company, or I pledge as part of a voting process. So this is what secures things. So, you know, somehow getting into my safe deposit box or using some coercive method to be able to get this allows them to, you know, to control it to their benefit. And so oddly, it's kind of like the pledge thing. It's like I still may think I own it and I have control of all those different things. But in the meantime, they've now got access to my entire world and life. So I'm hoping that your committee can find a way to make sure that this type of thing, where it's not precisely theft, it is a loss of control, of exclusive control that I have in some property by somebody else, you know, taking a measure of control as well. So.
Thank you, Mr. Allen. And another interesting point about that is, you know, I'm the thief, I steal that from you. What value is it? Like when you value it under statute, we're always looking for that $1,000. I think we're speaking $1,000, that's probably we've got statute, right? So $1,000, is it worth more or less than $1,000? Well, that object is worth a lot less than $1,000. What's behind the door is worth more. I guess this is something we've talked about before with keys. I guess if I steal the loan key to the safe deposit box, wow, I don't know what's in the box. Does that ever come into play, or is it just the value of it? What did I steal? How does the court handle that? Senator.
So unfortunately, I mean, in my opinion, you would still only be charged with a misdemeanor crime of theft, because what was stolen in the scenario of the safe deposit box key, simply the safe deposit box key, until they go access the safe deposit box key and remove the property, would it possibly be a felony at that point? But we don't charge people for what they could potentially do. We charge people with what they have done. So that's a very important concept associated with that.
Yeah.
Mr. Allen, go ahead.
Is depriving someone of, so that one of the big differences in the physical world versus the digital world is that depriving someone of access of or whatever is fairly trivial. I remove your access to it. But in the digital world, since you can make lots and lots of copies of things, the principle is much more about exclusive control. And is taking away my digital property by, in effect, removing my exclusive control. Is there any way to basically address that problem between a fundamental difference between digital property and physical property?
Senator, any thoughts?
So let's go back to the definition on page 4, lines 16 through 20. And maybe I pose a question to you, a little bit unorthodox, but tell me why you believe that this particular statutory section would not apply to that scenario.
Mr. Allen, have a read.
Yes, so a person is guilty of theft if he knowingly obtains, procures, retains, or exercises control over or makes unauthorized transfer of interest in a property of another person, and then supplemented with, A, B, C, D, et cetera. I believe it comes really close. I guess my question to you is, as I believe you're a former prosecutor or been involved in that side, how does future prosecutors who take a look at this go, yeah, somebody lost control or lost exclusive control. How do we make it a little bit more clear? So I don't have a suggestion on it. It could be that this is enough, but I just want to make sure that the sense of loss of exclusive control is what's fundamentally different about the digital world, and can we, highlight it a little bit?
So, Mr. Chairman, thank you. So I think it's important to look at page 4, line 19, what the language that's been stricken with the purpose of depriving. So in your scenario, you still have access, but so does someone else. And so what has been taken is the exclusivity. So this, I believe, still encompasses the loss of control over just some of it instead of all of it. Typically, it's associated with depriving you of all of the property, stealing your vote, right? But this is a loss of control, and it is silent as to how much control. So a point of ambiguity for the courts and juries to grapple with, but I do believe it would be encompassed in your scenario.
Thank you, Senator Nethercott. Yeah, if you just read a simple form of this, for example, knowingly obtains control over property of another person, right? That's exactly what you said. That's a true thing. So even if I copy your key, you can keep your key, and I still knowingly obtained control over property, your property at that point. So I think Senator Nethercott is spot on with the fact that it no longer requires any type of exclusive control or deprivation of control on your behalf. It's just that in the scenario that you're laying out is kind of a new one with property rights, where you I can secure multiple controls of a certain individual piece of property, which is much easier in digital space. So that's good job. Yeah, Mr. John.
A question. So we've had this discussion of what is the definition of control before. So in the computer industry, when we think about control, we have things like collaborative control, things of that nature, whereas the SEC has said control is exclusive control. So which do we fall in? So again, it's not that I don't have some control, because I may still have a copy of this. It's that I no longer have exclusive control. That's the loss that happens with the theft of a private key.
Thoughts?
Well, Mr. Chairman, a funny thing that lawyers say in this regard is the jury will decide. And so that does leave some people who want, definiteness, feeling unsatisfied. But that's how our system works. A jury determines that level of control. The concept of control is not new in the criminal law either. Exercising control over another person is something that's frequently prosecuted, litigated, and juries are determining that level of control. So, a somewhat unsatisfactory answer for you, no doubt, but the jury will decide.
So
Go ahead.
Sorry, Mr. Chairman. Is the being very explicit that it's exercises control or exclusive, somehow having something that's an or, exclusive control, or breaks exclusive control. I'm not sure what the right language is. I'll look here. But being really clear that part of what the loss here is of exclusive control.
Go ahead.
Mr. Chairman, to put it maybe in a different, more commonly understood concept would be, I own property with Senator Rothfuss, and he decides to give his interest in the property to someone else. I no longer have control with Senator Rothfuss over the property, but now I own it with 5 other people because he gave his property interest to 5 other people. Have I been damaged by that? Maybe. Was that his ability to do so? Yes. So those are some similar concepts associated with the dilution, I think, of ownership interests. where I still maintain my interest in the property, but I don't own it in the same way. You know, I own it with other people. So those are some concepts similar there, that there is some guidance in the law as to that, but it's going to be very fact specific and very fact driven to each unique situation, including with the keys. You probably won't have two fact situations if somebody without permission gets access to the key and you use exclusive control. So it will be a fact-driven, dependent inquiry.
One more thought here along these lines, Senator Nethercott. If I obtain his secret key, even by deception of some sort, so I'm a dodgy guy, I get his secret key. But he doesn't lose his secret key. I don't do anything with it. He may not even know, but I'm just trying to decide whether I'm guilty of theft under this. I could have control, but I'm not taking it. I guess I've procured control, but I haven't really exercised it. What's the point at which, and maybe we go back to this, I've copied someone's key to their house. Am I guilty of anything? No? Okay. Go ahead.
When you took the key to copy it, you'd be guilty of theft at that time. Yes. That's the moment, that's the crime.
All right, interesting. Thank you, Mr. Allen. There's certainly a lot of future interesting scenarios, I think, ahead of us when it comes to theft and digital property and assets, but we'll boldly go there. Thank you. Any further discussion? Please join us. Again, state your name for the record.
Chairman, Task Force. This is Devin James, co-founder of Alexandria Labs. I just wanted to add one extra point that mnemonics are a really important thing to keep in mind here, because the last point that was just discussed of if someone were to copy your key but not use it yet, they haven't broken any laws. The key to your house or the key to your safe deposit box. The problem is they need to have exclusive control over the key in order to do that, and as you point out, that's where they broke the law. When it comes to digital keys, what's going to become more common is mnemonics, where it's 12 words, and they're casual words, or dog, whatever. And so if I say to someone, say my wife or whatever, and someone overhears me, they didn't have to take control of those keys, but now they completely control everything, and that could control my house, my deed to my car, the ability to lease stuff out, etc. So I think there's certainly something to be said about the loss of that exclusive control being really key here, because there is no analogy in the real world. Like an actual theft, an actual taking away of the physical key had to happen for someone to copy it, and then there to be that threat of being able to deprive someone. In this case, they don't, and it could be you could have someone running an operation where they're stealing lots of keys and not using them yet in order to, say, sell that to someone else or someone else. So it just kind of could enable a really big crime.
Interesting thoughts. Do you have any thoughts on that, Senator? Anyone else? Please feel free to chime in. But a couple things that come to mind for me from that. First of all, there is the without authorization concept, and then that gets to the question of what an authorization means. If I'm accidentally saying something, if I'm saying something aloud intentionally, but someone else overhears it, how is that looked upon from an authorization standpoint? I haven't authorized them certainly to access those materials that are private materials, so that might still be an authorization violation if they actually go in, but I probably haven't violated a crime yet unless I go in. Does that seem fair?
Just a reminder, right now we are just swimming in one lane of theft, and so there's a whole criminal code of fun crimes to charge bad actors with, and so there's more tools in the toolbox than just this. And so again, it's going to be a fact-driven inquiry as to what the intent was associated with the bad actor. Inadvertently hearing information that they shouldn't have is not a crime, right? Doing something nefarious with it thereafter is, but knowing what that is and how that happens is a different question, and likely not theft. So important to understand that it's very fact-driven, and we have an entire toolbox of crimes to charge bad actors with.
On your question though, which is at least an interesting side concept, I think, with cryptocurrency, virtual currency, where the key basically owns to some degree the currency, it would be interesting to see how that played out, where somebody overhearing, as you said, a secret key that gives them access to cryptocurrency at that point. It's almost like the key is the owner instead of the person. I wonder how that would actually play out. Because your proof of ownership is the secret key. If I've got the secret key, do I then own the currency the cryptocurrency just as much as you do, which is a very different thing. And I don't know how that would happen.
Mr. Chairman, it reminds me of the whole possession is 9/10 of the law. It's very much where possession is a lot more important than what the law says in this case.
Yeah, that's weird.
You know, I know that there's desire to not create analogies, but in the law, that's very important because we base everything on precedent. And so analogies will be made and are appropriately done. But if you drop your $50 bill on the ground, it belongs to you, but you've lost it, right? You were negligent with ownership of it. You lost it, somebody else picks it up and uses it. Did they commit that? Maybe. You know, I mean, there's no statute of limitations in Wyoming for crime, so if you're cautious about answering that question, everyone in the room. But, you know, I think that there are some concepts here that, in common sense, that have to come into play. And again, the criminal code looks at intent of the actor to understand what crime would be associated with that intent.
Mr. James, go ahead.
That's all.
Okay, thank you very much.
Thank you.
Appreciate your testimony. Would anyone else like to provide any testimony on this topic? Anyone else? Please join us. We all know you, but state your name for the record.
Thank you. Cornish Anderson Kill, Washington, D.C., Wyoming attorney. Senator Nethercott, thank you and the Judiciary Committee for all the work you've done on this. This is bringing back terrible flashbacks of my criminal law class, as first year of law school. And one thing that I just want to note and ask on the record, the disjunctive in paragraph A1 and A2, that is, the end of A1 has or, A2 has and then the list of has 5 elements or things that you can throw around. Just for the record, would it be fair to say that control is a benefit that would fall into the definitions under Romanet 2?
Thank you, Mr. Cornish. Senator Nethercott, you want to follow up on that? Intuitively, I would actually say no, but that isn't necessarily something that has to take the case, but maybe Senator Nethercott.
Thank you, Mr. Chairman. This is one area that's being heavily reviewed. It's just the structure of this, not necessarily the concepts within them. So I just want to urge caution that this is a draft still. So I think if you look at Romanet, or page 5, lines 5 and 6, if you intend to deprive the other person of the use or benefit of the property, you know, regardless of how much control you're exercising, if you intend to deprive them of the use or benefit. Now, I understand that doesn't apply to the other scenario we're talking about of losing the exclusivity, because you still have the ability to use the property. But I think your concern is addressed there when it comes to control. The lack of exclusivity is going to be a little trickier to navigate, but I do believe it's encompassed on 416 and 20.
I guess where I was going with that was that. I guess where I was going with that is that I would argue that control is a benefit of the ability of somebody control issues that we're discussing right now would fall under that benefit definition to the extent that a prosecutor wouldn't be looking at A1. I think it's very, actually, my comment is just for clarification and actually to commend you all on a very well-written statute.
Thank you, Mr. Cornish. Any questions, discussion? Seeing none, thank you, Mr. Cornish. All right, any further public comment on this topic? Any further public comment? All right, seeing none, let's take a 15-minute break. Our next topic is scheduled for 10 a.m., digital representation tokens, and hopefully we'll be able to start right at that point in time. everyone.
That one actually did have a.
Before we start on our next agenda item, I want to recognize Representative Bill Henderson, who's here. Welcome. Thank you for joining us. Representative Conley was here a few minutes ago, but I think she's taken off. I don't see any other elected representatives coming. So, with that, committee, before we move forward to the next topic, anyone have any comments or thoughts? Seeing none, let's roll. All right, the next topic of consideration is digital representation tokens. We had some discussion at our last meeting in this topic area. We did some revisions to legislation and define where I set them down, but let's go into the updated bill draft and please walk us through the changes. Or Ian, whoever's Chairman.
At last meeting, we did consider this bill. It's out 20 LSO 152. You have a new version in front of you, which is version 25. There were two questions on this bill as of the last meeting. First, we talked about whether it was appropriate to have special purpose depository institutions included. The original bill draft gave them authority to issue digital representation tokens. LSO was directed to remove that, and so this revised version does not include anything about SPEIs and their authority. Then the second thing was there was a question about whether the provisions of this bill might impact or conflict with Wyoming's Utility Tokens Act. And indeed, I think that was a good call, because when we went back into that, the Utility Tokens Act directly says that these utility tokens, open blockchain tokens, that have a consumptive purpose are personal property. And yet in this bill, this task force is trying to identify situations and announced a broad rule that says that if it meets the definition of a representation token, it is not individual personal property. And I think it's pretty clear when you look at the definitions that there are certainly utility tokens likely are a subset of digital representation tokens, and therefore there's a conflict. So, legislatively, it was pretty easy to resolve that conflict, and that is by adding the second on page 3 of this draft, in lines 15 through 18, we've simply said an open blockchain token qualifying as an intangible personal property pursuant to section 106, which is the Utility Token Act, shall not be considered a digital representation token. That resolves that conflict. The question, I think, for the task force, though, is, okay, to what effect? Now we've said that a utility token can't be a digital representation token, but aren't they the same thing? And in fact, they are, but we have a conflict there. So I think that's a policy for you to resolve.
All right. Anything else before we start discussing that, Ian?
Chairman, no. Do you have any questions?
All right. Thank you. Let's go back to the committee then and try and resolve that and what we want to do, if anything, with it. Any thoughts, committee, on
Mr. Chairman?
Yeah, Ms. Long.
I've been nervous about that conflict and it sounds like you are as well. We also were just last week submitted what I think is a better idea by Doug Pepe, who's been here before. He's on the American Law Institute. He's a securities litigator who also happens to be a blockchain developer. And he actually has been working on Delaware statutory trusts to do exactly what this concept is. And he proposed creating a new vehicle that would be a blockchain asset. It would be effectively a statutory trust. He said the problem is Delaware statutory trusts weren't intended for this, and so they're not perfect. It was the best thing available right now. Of course, Wyoming has statutory trusts as well. But long story short, I think that's a better approach than trying to define the token as the asset, because if you set it up in a new vehicle, it's easier to have the rights and obligations, run with the token. And frankly, I just think it's a better approach. We didn't have time to be looking at redrafting because that's what this would have meant. So I would propose that we set this back. We have a better idea, and there's no reason to rush this through. I don't know if the committee's interested in working with Doug on that idea to have it be brought up as individual bills that potentially you legislators would sponsor, because I think there's a powerful concept here. It's just that
we've tried to define the asset as the token, and we've run into a lot of obvious problems, and I think his idea is actually better.
Right. Thank you, Long. Any additional thoughts on this? One thought I had when I was reading that email and thinking that through is, I don't know if there's anyone doing that right now. I mean, the statute seems to fully allow the trust asset, a statutory trust asset, or the statutory trust itself, to obtain assets, and then the trust, based on previous work we've done, ownership of that trust can already be tokenized. So I kind of feel like you could do it. Representative Olson, do you have any thoughts on this? None. I thought you did that and pointed at him. That happened. He changed his mind. Mr. Kaufman, you kind of work in this space, and have you had any thought about that exact thing? I mean, do you feel like we could already do it with the work we've already done? If somebody wanted to just create a trust, put an asset in the trust, and then tokenize the ownership of that?
Yeah, Mr. Chairman, potentially. I agree with Caitlin's comments. I think this approach gets a little messy, and it's probably largely unnecessary. I mean, we already do have the tokenization authorization for shares, and then in conjunction with the Utility Token Act. So I agree. I think this is probably unnecessary and a little messy.
Okay. Committee. Any further thoughts? Yes, Mr. Chairman.
Thanks, Mr. Chairman. I just want to commend LSO staff in this regard with the deep dive that they've done. There's quite a bit of communication back and forth, and you can see the staff comments throughout the legislation pointing out some of the difficulties. You know, as is often the case, we have some pretty wild ideas in this committee, and really thankful that we've got an outstanding LSO that every once in a while says, slow your roll. Screw up what you've been working on for the last 2 years. But it's appreciated.
Well said. Anything else? Anything else before we go to public comment? Seeing none. All right, let's open the floor to public comment then on this bill draft, and even as a concept. If anyone has anything else to add as we're thinking about it, working through, please come on up, join us. Introduce yourself and who you're with. Not yet. There's a little switch right at the top. The light will turn green when you are ready to go. Game go. Oh. Well, let me do that. Okay. It's working.
Yes. Thank you, Mr. Chairman. My name is Scott Muller, CEO of Amship, based in Silicon Valley. And really, I just want to request a point of clarification in this, because a couple of things kind of threw me off as I was reading. On page 2, it discusses an open blockchain token, and I would just like to have clarity when you're referencing an open blockchain token. I understood this is existing law, but does that mean whether that token, and also in reference to virtual currency as well, in that definition, does it mean whether it's both in a permissioned and non-permissioned environment?
So that is all existing law, and what you see is amendment. So when you're looking at page 2, for example, of the bill, and you see the red line insertion, we were trying to clarify a specific type of digital representation token and go on talking about how that would be used, and then you see additional language on page 6. What's there already is the existing law from 2 years ago, amended last year, on open blockchain tokens. So that's already in statute, and that's pretty well developed. Now, will you repeat your specific question about how the open blockchain token in existing law, which sounds like it's the second half of the question, how it behaves?
What I'm actually looking at is how would a stablecoin be considered in the ecosystem in Wyoming if that stablecoin is operating in a permissioned environment? So it's not available for everyone to buy, but it's available if you've been vetted to enter the ecosystem.
A permissioned stable coin. A virtual currency is not going to be covered under this. If you're going to call it a virtual currency, then it would not fall under this. The permissioned, I'm wondering if there's any nuance in statute as we've written it so far that would change that? I don't think so. It's still going to be a virtual currency. Committee, any further thoughts on that? think that's accurate. Since you have an underlying virtual currency, even if it's virtual currency, I would expect our virtual currency statutes, which are exclusively covered that. But again, I will ask you to consult your local attorney. Thank you. Thank you. Any further public discussion? Yeah, please join us.
Mr. Chairman, Task Force, Devin James, Alexandria Labs. It sounds to me like the idea of using a trust to make this work is quite appealing, but I just wanted to throw a potential twist. Thinking of the example of an open source Airbnb in which the owner is able to grant access to their home using a token. So the renter rents for a weekend, they send the token to an email address or something basically, and the renter receives that token and it actually gives them digital access to the locks. So it sounds like the way that the trust would work is that they have to put that asset into the trust and then they'd be able to issue an asset. Well, I shouldn't have to put my house into a trust in order to be able to do that. Would that be a limiting factor? Is it still going to work?
I think you might, again, we're sort of speculating in how best to do something from a legal standpoint, but Mr. James, once again, I feel like there are mechanisms where you end up using you might use a consumptive token as access, and then you might have ownership of the entity in the trust or an LLC, and you can still, once again, tokenize an LLC shares as well in ownership. So I think, again, the statute currently covers it. I think there'd be a multitude of ways that you could go about doing what you just described, depending on certain aspects that you want to take advantage of. We have the mother and child corporations, basically saying that.
Like a series.
Yeah, like a series of LLCs.
I think that's a good example. Mr. Chairman?
Yes, go ahead, Mr. President.
I actually think the point made by Mr. James is good, because I think it's, if you remember what a consumptive token requirement is, there are a lot of security type requirements, not all, right? Not all, but still quite a few that go in place with a consumptive token. And if it's for something like Airbnb, you don't have to go through all of those steps in order just to provide access to an Airbnb. So the only other option at that point is kind of live in this gray area. You know that that token is not going to be purchased for the purposes of resale value, like a security token. You don't want to go through the consumptive token aspect because it can be a bear, and it's that a consumptive token was never designed for this type of work process. So that might be, I might be changing gears. I might be advocating for now on this piece of legislation just because there is that gray area.
Mr. Co-Chairman, no, because you don't, again, you just use two different tokens for two different features based on what we were just discussing. You have an ownership token, which owns the Airbnb, and a consumptive token that, you issue one every year. It's a 365-day consumptive token where access rights for a given day or a week, I'm buying access through my consumptive token for May 5th through 12th. At that point, it's clearly consumptive.
Mr. Chairman, I don't disagree that it's consumptive. I do think that it can be a consumptive token. I'm just saying you would not want to go through that process of setting up a consumptive token for this purpose because of the hurdle you have to get set up to go through to have that consumptive token with the Secretary of State's office. Also important to note that Representative Yin amended that bill to allow for a $2,000 setup of this consumptive token. So it is an expensive area to be able to go through this, and it would be much easier just to provide a key or a digital pass, something on the door.
Right.
So I think when we're looking at this, is this too much of a barrier to be able to utilize this technology in this way? And I think Wyoming's laws are now in a place that it is too much of a barrier to be able to utilize in this.
Mr. Chair.
Mr. James, go ahead.
I just wanted to expand the example too. It's a lot more than just homes. It's also going to be car rentals, and I know scooters aren't going to be as common here, but things like that. Like especially as the value of the thing gets lower, and the demand to kind of rent it in smaller quantities goes up, this is going to be harder and harder to do.
Thank you, Mr. James. Representative Young, would you like to respond to one of the boss?
I did purposely put a barrier. I don't remember if it was 2,000. I think it was actually less than that. But the idea of the barrier was to make sure that we trust who we're allowing to do this.
Right, and go ahead, thanks, Mr. Chairman. And Representative Yen's absolutely right. That barrier was there for these ICOs, right? So that we know that ICOs that are coming into the state of Wyoming are a good purpose, that people are not just filing to file, as we saw with the Secretary of State's office under the passage of our initial legislation. Without that barrier in place, we saw a lot of essentially spam coming in. But it still puts the consumptive token in a very separate class unto itself, where you would not use it in a situation like this for a daily kind of use. And I'm kind of going back and forth here. I know I started out, and I think staff's comments are great, but I do think there is a purpose for this. Can we come up with that?
Well, Mr. Chairman, I see what you're saying. So the idea, I'm going to have 100 little scooters, and and I want to have a consumptive token for each of the 100 scooters, and I don't want to have to pay $200K for that. Is kind of what you're getting at. So how do we come up with a system where I can do that? The consumptive token works for it. You're just, as I understand it, your only concern is the fact that we were looking at larger ICOs with the initial concept. The $2,000 barrier is a problem. So maybe we need to look at just that aspect of it. I don't know that we have to add an entirely new class. We just might want to figure out what we can do about that, so that at the same time it's not super easy to spam the Secretary of State's office. How can we do that? How do we set it up so that, and maybe we could have children consumptive tokens?
Mr. Chairman, I don't disagree. I just don't think that, I think this can fit the consumptive token. I just don't think it should. Why? And my reason on should is what we've set up and put in place. These are all required filings by the Secretary of State, where this is something that is very much just a utility type of use. There's no reason, much like the QR code with the cards that we got yesterday, that would be something that would be a digital representation token. And I would argue that no organization is going to want to set up something like that and have to, settle with the Secretary of State before they hand out coffee cards.
Mr. Young.
Mr. James, go ahead.
One more example. Access rights to digital things like listening to a song. I might spend $1 and get a token that gives me the ability to listen to that song, and because I hold that token, I can then sell it to someone else when I'm done listening to it for, say, 50 cents. The point is, this is a way that you can really bolster a growing music business if independent artists can sell their stuff without having to go get a license just to sell a song. I think that could be a very limiting aspect.
Okay, thank you. Yeah, I was going to do exactly that. Ms. Long, thoughts?
Thank you, Mr. Chairman. Thank you, Mr. Chairman. I think the idea is to create a new asset class that would have to be much easier to register at the Secretary of State's office. And the difference is that these are designed to represent real-world assets. That's the reason for this. It's not the digital access rights. No question digital access rights is already covered by the utility token bill. This is essentially getting at a car or real estate, so it's not even an access right from an Airbnb. It's the actual home that this is meant to represent. So it is different than the utility token. And your point is well taken, though, Chairman Lindholm. We don't want people to have to go through a huge number of hoops and costs to register these. We had the conversation regarding Cowboy Coin about being very careful. I believe you're planning to turn it off after the hackathon precisely because we don't have a way to control out-of-state users, and if it's a local thing internally in Wyoming, it's easier. Okay, I'm not correct on that, but we just didn't want to have any legal questions about it and as to whether it's a security or not, and the security issue is a whole messier issue, of course. But the point is that We want to be able to encourage people to create cowboy coins that, you know, we have a private key on the little credit card like piece of plastic that Consensus handed out. And that is different than a digital access right, because it is tokenizing a cup of coffee as opposed to creating a truly consumptive coin. But you didn't want to have to go through it. It wouldn't have made any sense for you to have to go through and pay $2,000 to the Secretary of State to register that.
Thank you so long. Mr. Allen's joined us. What are your thoughts?
Christopher Allen, Blockchain Commons. So, reading this bill, I felt uncomfortable about it in a couple of different ways. I understand the niche, but the language didn't quite feel that it matched what I thought the intent was, and now I'm hearing even more. What I wanted to do is to bring a little bit of the technological perspective. Increasingly, we're coming up with these new, very limited what are known as capabilities. That's the technical term. So object capabilities is the longer version of this, which can be for very small things. In a sense, when you buy the right to read a newspaper article using Lightning payment, you are getting a token that is not really a fungible token, but neither is it exclusive to you. You could pass that to somebody else instead of actually using it to read the thing. But they tend to be very low value. They tend to not quite be fungible. So there's a big difference between the access to a scooter anytime as a utility token versus access to that scooter for one day. Object capabilities tend to be more exclusive for either a period of time or for a very specific device or a very specific article. Theoretically, I could see somebody buying, say, a ski pass for the 25th of November, and it's going to be an absolutely amazing, beautiful day, and they sell that for, 200 times the price because somebody really wants that perfect ski day. So these things will be sold, but it's only that day and it's only that particular place and time, and you're not really speculating in the same way. So I would like to see someplace a carve out for these object capability things.
Thank you, Mr. Allen. Yeah, Mr. Coffin, go ahead.
Sure, I was going to weigh in a little bit.
And I might have a minority view on this point, but how I see this is obviously we have security tokens, right? Clearly securities. We've carved out this utility token mechanism for a consumptive purpose, and now we're talking about sort of access rights. And so far, at least as far as I'm aware, the SEC or no one else has really come down on just the pure access right, unless you sell it as a security. It all comes down to how you conduct the offering. So if you, and that's why we have the utility token offering exemption the way we do, because if you're selling it as a quasi-offering, right, you have to be careful about what you promise and what you tell people that they're buying. So to me, that's the distinction here. If it truly is just access, not access to an asset, but just access to use the asset, that's a fundamentally different conversation than transferring ownership of the asset. So when we're talking about the house, that's one thing. When we're talking about just the right to use the house for the weekend, to me, that's a completely different analogy. And again, this bill, in my mind, doesn't solve that problem at all. And quite frankly, I don't think this bill is necessary to solve that problem.
Agreed. I don't know what the solution is, though. Go to Ian. Yes, Ian.
Mr. Chairman, I think, Mr. Kaufman, I think kind of hit on the head there, because one thing I think you do need to recognize is that this bill, particularly as currently drafted, accepts utility tokens entirely. So if you meet the definition of a utility token, this bill is not going to do anything anyway. A consumptive purpose is currently defined in the Utility Token Act to mean circumstances when a token is exchangeable for or provided for the receipt of services, software, content, or intangible personal property, including rights of access to services, content, or real or tangible personal property. And I would say that definition is fairly broad at this point, and I think it was initially suggested. If you really want to get at this issue, the
point, and this is why I hesitate to not do anything, is because the consumptive token, there should be an exemption in there, because we do not want to incidentally grab or basically ensure that some of these companies are not going to operate in the state of Wyoming because of that legal gray area on something that they're doing differently. And so what that looks like, I don't know. I don't know if it's this vehicle or if this is a good starting point, but I do think it is enough of a point to worry about, because when you look at events such as the hackathon that we're currently about to have, the F Denver that shook out, all of them are using those types of access. And wait, I mean, yeah, I think
Nobody registered them anywhere.
Yeah, I think this is a bigger deal than.
Mr. Co-Chairman, would these all, though I'm trying to think if any of them would fail to fall under our open blockchain token architecture were it not for the registration fee. It seems like if it were if it were $0 registration fee where everyone could just register, then I think that covers the individual scooter registration, where my scooter is tokenized for use, not for ownership. For ownership, you still want your LLC or your trust to be tokenized, but for use, clearly that's not going to be a security, so we're okay to tokenize use of it over time. But obviously, there's no way that you'd want to pay a fee for that, even over a 50-year period, probably for token use. So, do we already have the statute in place that covers all of the use cases we've talked about today, and we're just concerned that it's too onerous to register?
Mr. Chairman, not only is the fee too onerous, but the requirements as far as reporting through the Secretary of State's office is too onerous. I mean, there's a lot of reporting that happens with a consumptive token, and not as much as a security token, but still quite a few. And my preference would be just a flat-out exemption from the Consumptive Token Act for using all that looks like this. And you could lay out, listen, you're exempt if you meet the following qualifications, but you wouldn't want to touch it. The state of Wyoming doesn't want to even know it's there. Nor do they have any business knowing that it's there if it
Right.
is a disqualification.
Right. So putting in language, for example, Mr. Co-Chairman, that if the value of the total services asset, or whatever the total consumptive value, we'll say that, of the token does not exceed whatever that number is going to be, $1,000.
Maybe you saw the filing fee for a consumptive token.
Yeah, you get into a little bit of a gray area where at that point you've got something where the value is $1,800 or $2,200, and basically $2,200 by the filing fee. So, but something along those lines, I think, probably takes care of it, where we find a low value. The other thing we can do is we can change the filing fee to a percentage of consumptive value, which probably makes more sense to begin with. Because there's still going to be the owner's burden associated with it. It's true. It's long, go ahead.
I'm sorry. May I just add that the whole reason for registering with the state is because there are special rights conferred, right? That's the whole reason why you create a corporation or an LLC and register it, because you get special rights. It is a creature of the state, and I don't think cowboy coins should, or anything like that, should ever have to register with the state, because there are no special rights that need to get conferred with that. The idea, though, here of using a token to represent a real-world asset is that you do want the restrictions and covenants associated with that real-world asset to transfer with the title, so with the token. So there is a creature of the state that starts to come into play when you basically, it's just like the concept of in real property law that your restrictions and covenants run with the land. You want them, when you're trying to tokenize something in the real world, you want all those things to go with the token.
in the same way. So that is something that the state would need to specify. But where we're just dealing with something where we're tokenizing a couple $1,000s worth of coffee for, you know, participants in a hackathon, why would we have anybody ever register with that? There's no reason, they don't get any benefit to have to register with the Secretary of State. There's no reason legally that the state is conferring special rights on that.
But I do think, Ms. Long, that we need to explicitly indicate that you're not, we need to provide a carve-out basically for exactly what it says. To make it clear that if you don't need, if it's a small total value of services and you're not going to get any of the benefits from the Secretary of State registration, that we're okay with it. Because I don't know that that's okay right now. I would say that it's probably not okay right now. Committee, further thoughts? Mr. Allen, thoughts?
So I think the dollar value is worth exploring in a couple of different mechanisms there. But I do believe that fundamentally there's a difference in the fact that, you know, title's not being conferred. The access is limited in some fashion by time or to a to a specific thing that disappears like a coffee. So there may be some other ways to qualify that these are not things that the state needs to care about. Now, it still might be useful for the things that are kind of in the gray area for there to be no fees associated with it, but yet have the protection. I mean, I could see some ranch basically tokenizing, access to the, exclusive use of the horses at this ranch for parties and things of that nature. That somebody might have a value higher than $1,000, and yet it's still, not a title. It's not. If they don't use it that day, you lost. So I think that you may want to have some, in the utility thing, some carve-outs in that sense. Thank you.
Thank you, Mr. Allen. Additional discussion, committee. Ms. Long.
Mr. Chairman. Sorry. Mr. Chairman.
It seems like we need to do something, but I'm just not sure we're there yet. And so the question is, do we carry this forward with the expectation that it's going to be rewritten before it goes to a committee? Or do we just set this back and bring up new legislation and maybe a small group of us go work on something that both gives a de minimis exemption and creates the concept of, if you remember how this whole thing got started, it was the request to tokenize real estate. So the two different things are quite different.
Yeah.
Real estate is, again, a creature of the state. There are rights and obligations conferred by law. And so that's very different than a de minimis consumptive token for coffee.
Well, yeah, I think this bill, as we have it right now, seems unnecessary. We probably just want to say goodnight to this bill. And I do think that even the real estate and everything else we've talked about, we have a legal structure in place to appropriately tokenize it by having ownership in a certain market, in a LLC or whatever the person needs to be. But getting back to these de minimis use and relatively small value on blockchain tokens, we do need to come up with a solution there. It's not going to happen here today, so I do think that probably ends up being an individual sponsored bill that we work on to try and tweak blockchain legislation or open blockchain token legislation. And I don't think it has to be a major change probably to accomplish what we're talking about, where we get that small carve-out. Representative Olson.
Yeah, Mr. Chairman, thank you. I don't know, I kind of feel like this bill is that solution. I don't know why it can't happen today. I think the de minimis use case is exactly, it's the nail on the head. And I've yet to actually hear in the discussion today what the risk is actually in moving this legislation. In moving this forward as legislation, I actually see more of a benefit. I'm very nervous about the idea of pointing the fee as an adjustment, and I think because that fee serves, I agree with Representative Ian's purpose of the fee, although I don't necessarily agree with the amount. But I agree with the purpose, and the purpose was to weed some folks out. But this answers an obvious question that I'm hearing in some of these, I mean, the cowboy token is obviously a good example, but I think it answers an obvious question. And I don't understand the risks with it. I just see a benefit to it. So I don't see why this isn't our vehicle. Maybe we can play with this some more, but I'm also nervous about us instead going through some type of carve-out, as we've been talking about, or an exemption, because the whole idea is to be outside of that regulation when it's completely unnecessary. And then this is exactly, this does just that.
Mr. Co-Chair. Yeah, thank you, Mr. Chairman. Would it be possible to ask the Secretary of State's office to talk about the requirements for a consumptive token and the reporting requirements?
It would be very possible. I've been waiting for you to ask them to come.
I do like to go to the Secretary of State.
Thank you. Welcome. Take your name.
Mr. Chairman, members, good morning. Kelly James, Wyoming Secretary of State's office. So yes, when this bill went through last year, we had a $200 fee associated with it because that is the fee for most of our notice filings with securities related. Now, of course, we said this is nothing to do with securities, but it was bumped up to a $1,000 fee.
Thousands, it's not quite 10 times the amount, not 5 times.
And Mr. Chairman, I'll tell you, I've not received a single one.
Request?
One of these filings.
What about prior to the increase in the fee?
Prior to that, we received 30.
So that's usually that effect. All right.
Mr. Chairman, and we do, I mean, as far as the cowboy coin, that was given away for free, so that would never be subject to filing with us.
Okay, thank you. Mr. Co-Chairman, go ahead.
Yeah, thank you, Mr. Chairman. Ms. James, can you speak to, I guess, two questions. Can you speak to the other requirements for consumptive token filing besides the fee? And then also, would the Secretary of State's office look at something like the cowboy coin if it wasn't given away for free, even though it's a de minimis amount? It's clearly for a special purpose. It's clearly not something that your agency would, I'm guessing, most likely want to regulate. But would you feel obligated to regulate?
Go ahead.
Mr. Chairman, Mr. Co-Chair, yes, I mean, I feel like we would look at it. Would we do anything about it? That would be a different story, but it would depend on the circumstances. But I think there is some obligation there to look at things like that. The enforcement authority that you put into the bill gives us that authority. As far as the filing itself, it is a 2-page document that is filed with us, and then $1,000.
Go ahead, Mr. Chairman, anything follow up?
Yeah, thank you, Mr. Chairman. Ms. James, so the $1,000 filing fee, what's contained in that single page as far as what is a corporation required to report to you? 2 pages, pardon me. 2 pages and $1,000. Besides the 2 pages, what is actually contained in the 2 pages? What do they have to report to you? What kind of information?
Mr. Chairman, it's on our website, and it's contact information, token detail information, and that is just built right out of the statutes. We pulled that information just to confirm that those requirements are met. But the purpose for the token is something, they have to click yes next to the box. All of everything down the statute, you just have to say yes or no, and then there's detailed information to explain. And so the intent, of course, if we were ever to receive one, would be to confirm all that information is correct and then file it. And there's a signature at the very bottom, just certifying that you are complying with that statute.
One quick thought. Thank you, Mr. Chairman. Ms. James, in your opinion, I mean, we went from 30 filings, some of which were spam, down to 0. Do you feel that the $1,000 fee has been somewhat of a barrier from some filings?
Go ahead, Ms. James.
Mr. Chairman, Mr. Co-Chair. Likely, yes, I do. I also do see these ICOs kind of trickling off a little bit. We haven't seen as many. Mr. Kaufman and I had this discussion that we are seeing more security tokens. People aren't messing with the consumptive part. If they want to, they're tying it to a security and they're filing a Reg D or a Reg A filing with us, and they are actually a security token.
Thank you, Mr. James. Any further questions?
One follow-up.
Go ahead.
Would the Secretary of State's office be, Ms. James, if we were to change that $1,000 filing, maybe bring it back to $200, because if we are blocking industry from coming to Wyoming, that was not the intent. I don't believe. Would the Secretary of State's office be comfortable with that?
Go ahead.
Mr. Chairman, absolutely. I think having the $200 fee would still keep the spam away and might encourage others to file if they want to.
So, when we're talking about these consumptive tokens, though, we kind of made an initial assumption that this ICO would be kind of one big thing, would have a lot of value itself, and structured it such that it precludes many small value tokens. So, seemingly, a lot of what we're talking about, a better value is to have the individual scooter being a consumptive token. So the scooter's year as a consumptive token, and then I've got 100 scooters. At this point in time, if I were to do that, I would have to file 100 different times. I have to sit there, I think, right? With the way the software structured, the web interface, I think I would have to sit there and type it all in 100 different times and pay $1,000 for each, because there's really no catch-all. Although, so I'll ask if that's the case, but then I'll ask the other question is how we can know the difference. So what are your thoughts on this?
Mr. Chairman, the form doesn't ask how many tokens we're issuing. So, so we don't have one filed for each token. We have one filed for, and I think at that point that's just access to
Yeah, what exactly, what are we giving them authority to do when they, is it authority to create a single token per $1,000, or is it authority, or are we registering them as an entity that creates open blockchain tokens? What are we doing?
Sorry, Mr. Chairman,
Mr. Chairman.
Go ahead.
Yeah, other than, hanging Ms. James on the,
Yeah, sorry,
I have the statute in front of me, so, so I think the statute is unclear. It doesn't specifically say, it talks about token in the singular rather than plural, but I think it likely contemplates that a token for a single purpose would likely only require one filing. I don't think that it at least explicitly doesn't require that there be, if you're gonna open a business that provides utility tokens for scooters, I don't think the law would at least explicitly require a $1,000 fee for every scooter as long as the tokens are used for the same purpose in the same system.
And, okay, so we really have a little lack of clarity, I would say, in that case as far as, and how different can I be if I use scooters and Airbnb is going into tokens at that point? There's different things that I'm tokenizing, but I have 20 houses and 100 scooters, maybe I need to. I guess we don't really have a great deal of clarity on one business.
Well, and Mr. Chairman, thinking about that statute, I wonder, we keep talking about the example of 1,000 scooters. If the token is just for the scooter business, but what if, there's a million different scenarios. What if the tokens were, you sold different types of, you transfer different types of tokens, one for a day use of the scooter, one for a week use of the scooter, one for this scooter versus that scooter, because they're different, they're different levels of scooter. Just like is it like if I'm renting a car and I'm renting the SUV, but I could rent the sports car, or I could rent the, so is that really one token? So I don't know. Maybe there is a very big clarity issue in that statute.
Any additional thoughts?
Mr. Chairman, we'd certainly be willing to work with whoever would sponsor a bill to help tighten that.
Mr. Chairman?
Yeah, I think it's also important to know, Mr. Chairman, that when we talk about the developers of these tokens, these consumptive tokens, they might be developing for a broad range so that secondary companies can use their token
you know, as long as they meet the requirements, hey, it's for consumptive purpose, you might have one token being developed that might do the scooters, that might do the Airbnb, and on down the line. So, you know, so that's kind of the broad use case. And that's really, in my opinion, where something like this comes into play.
And I think we also want to be very careful that people don't have to code or create a product in a certain way because it's more cost beneficial under Wyoming statute, if that makes sense, right? We don't want to have to drive the coders into coding a certain way that's less convenient. That's certainly not the intent of how we structure statute, but I actually think that we probably wrote a statute that would do that, where you'd start designing your token model based on what is the lowest cost compliance approach to Wyoming statute, which is offered. Representative Yin.
Mr. Chairman, thank you. I'm just trying to get some clarity, but I think if I remember right, the statute, which also provides some clarity, is one, the filing fee is so you can issue tokens, not for each individual issuance of tokens. And two, in the filing, you describe what the token is representing in a consumptive way, and so that doesn't necessarily mean one thing. It could be consuming certain things if you want, but I think, if I'm incorrect, please correct me, but I think it's just to describe what the token is, and if you wanted to change it, I don't know if we have any change of filing fees to change what the token would be issued, but ideally, the idea would be if you are filing, so the thought process in my head during the session when I brought up the amendment was, if you are, one, it's really easy to create an ICO, it's extremely easy, but two, if you're doing it in a way that is not attempting to scam people and to make money by providing value of some sort, and then you also want the stamp of approval from the Wyoming Secretary of State, it's that clearly this is going to make money, so I don't think $1,000 is that big of a deal to make sure that is the case. But I would like to hear from any businesses that say that this filing fee is blocking them from doing an ICO because it is not profitable to have this filing fee. I would love to hear that. And then secondarily, I would love to hear what kind of carve out we can do to make it so if you're just like experimenting or having like small things, so we could have that de minimis carve out as well.
Yeah, it's more like a licensed ICO than an individual cost of ICOs or something like that, and that might address this where we then don't get into the game of telling them how to ICO. Representative Olson, do you want to weigh in? You look like it.
Yeah, I was just confused because the question was how do we carve it out, but I think we have a bill in front of us that does that, so I'm just confused. I really think this bill answers that question.
I really don't think this bill does it. What does the rest do? Mr. Chairman. Mr. Pop, sorry.
Mr. Chairman, I'm sorry. I think this is a mess right now. I really think if we're talking about utility tokens and the de minimis exemption, that's one thing. Right? We could create a de minimis exemption so people don't have to file a fee. Fine. Or if we want to change the filing fee, that's one conversation to me. If we're talking about authorizing the tokenization of a real asset that the state has an interest in that we want to track and be able to attach a property right to, there's no way this bill accomplishes that. I think this is a disaster. If
a disaster.
Yes.
If so negative. Is that a sense of negativity?
Yeah, and again, if we're caring about the realms of sort of the security token side, again, I would caution us to stay away from that because I think the industry is sort of finding the answer there within the securities regulations as they exist. So I'm just encouraging you, Mr. Chairman, to refocus this. If all we care about is the filing fee and the utility token, fine, let's fix that, not through this mechanism. If we care about authorizing tokenization of real assets that we track property rights with, let's do that too, but not through this mechanism.
Mr. Coffin, before we go on for a minute, and I'll go down this one in a second, but while you're on that point, do you see anything with regard to tokenizing real assets that is insufficient with regard to current statute? Because again, I can put it in the name of an LLC or a trust, tokenize the ownership of that trust or LLC, and at that point in time, I believe I've tokenized real property.
Yeah, so if I'm understanding your question right, do I see anything in the statute now that prohibits you from tokenizing an asset?
Or that's too weak, or that doesn't work well enough, or?
No, I don't, quite frankly. And that's why I don't think this is necessary. I mean, I think we already have the structure in place if you want to tokenize real estate, for example. What matters to the Secretary of State is the offering mechanism and how you go about doing that. What are you promising to people? How are you conveying it to them? What is the value that they're receiving for their investment? That's what, right, securities law governs. Otherwise, the rights to the asset should attach. So if we want to carve out a separate right or mechanism to clearly define it, I think that's okay. But I don't think this bill does that at all.
We go to Ms. Long real quick.
Thank you, Mr. Chairman. Yes, I vehemently agree with Mr. Kaufman that if I could just step back and state what I think is a principle that we should adhere to, and I think we have generally. We don't want to impose bureaucratic burdens or costs on this industry unless the industry is getting something back from the state. And I'm talking about not the state of Wyoming, I'm talking about small s state here. Why do they get some benefit? It's typically limitation of liability, which is why people put corporations or LLCs together. And for that, because there is an administrative cost for the capital S state of Wyoming, it is not unreasonable to ask people to pay a fee and fill out a form. But in general, if there's no special right that's being conferred, why would we have this industry have to go through any interactions with the small s state anyway? So I think that's a good principle. And to your point, Mr. Kaufman, I think the issue with using a statutory trust or an LLC to tokenize real estate right now is that you don't actually have those covenants and restrictions passed with the token. And so if we're going to go down that path, we actually probably do need to address that in statute and have people pay to get that protection from the state. That's a creature of the state at that point. This is exactly Doug's point that using Delaware statutory trust to do this isn't perfect because all the rights don't pass through the trust. So that is something different than what this bill is, for sure. And I think his idea is really powerful because it does get back to what we were trying to do, and Teton County's leadership in this is so important. If we're ever going to make deeds tradable, we don't have the regulatory structure for it right now.
Yeah, Mr. Chairman.
Yeah, thanks, Mr. Chairman. I don't disagree with Mr. Kaufman or Ms. Long in the regard that these functions are there. But I think it's also important to remember the reason why Wyoming is in the place we're at right now is because we were very specific and we put things in statute. It's arguable you can do security tokens in the state of Wyoming without us passing a law. The reason why we have security token filings now is because we did pass a law and we did say this is how you do it. So that not everybody's Mr. Kaufman. You know, not everybody has a security attorney in their own head. You know, so that's, I don't disagree that this might not be it, but I do think it is something that we should all put some heavy thought into putting in law based on the premise that a lot of times what we put in the law acts as one of the best advertising aspects the state of Wyoming has. And so if there's a way to get this there, I'm looking at the brains in this committee, then we should try to.
Mr. Chairman?
Go ahead, Ms. Long.
May I propose, we've done this a couple of different ways in the past. One option is to roll this forward with an express understanding that it needs to be worked on, and take this into maybe the Corporations Committee, and then maybe a group of us work on it between now and the Corporations Committee, or the committee assignments are yours, but I'm not averse to that, but I just want to make sure everyone recognizes that this is imperfect.
Yeah.
Any long additional discussion?
Well, Mr. Chairman, I just want to echo some of the things that the co-chairman said, because as I think more about the $1,000 fee, and I think about, I don't disagree with Mr. Kaufman's legal analysis, but I think that is a reality that if you're not ponying up $1,000 fee for something that is so de minimis, you're probably also not jumping on the phone with a lawyer and paying $300, $200 an hour to get the advice to figure out what you can and can't do. But I do agree and believe in the if we build it, they will come concept. And I think, if nothing else, this acts as that advertisement for some commercial activity, which granted is probably very minimal in the use. But I like the Airbnb example because it's so, Airbnb is so counter to what we have operated inside of our country for, decades of how we transacted with travel and in the hotel industry, the travel industry, and et cetera, and it just really flipped this on its head. And so how do you know that something that de minimis or that unique is going to come out of this? And so I agree with the idea of moving forward. I think there's a lot of options in order to work this bill to make it fit some of the conversation that we're having, but I just sure hate to lose the conversation in losing the bill.
Representative, the concern I had though was with Airbnb and those types of examples, this language on page 3, Roman 5 just absolutely doesn't cover that. This is very specific to ownership of real property. It's not anything similar to a consumptive token from that standpoint. It's the ownership. It means a digital representation by which a person's claim to an interest or right in real or personal property is evidence. So we're not talking about the Airbnb. That really is over on the consumptive side, but we've got a high price tag on the consumptive side. This is the idea of the ownership, and my understanding of concerns that were expressed by Ms. Long a while ago is the confusion of what do you own? Do you own the token or do you own the real property? And trying to make sure that there's clarity there, that this doesn't get to as part of the concern. I think that's at least part of the concern, as I understand it, as expressed in some email contact that we received. So I think we all kind of want the same things in the end. It's just what the path towards that is. What's the best statutory path to get us to the point where we can have easy access to consumptive tokens for the scooters, so that we can have clear, what we're calling a digital representation token here, though, where a token does represent the piece of art on the wall. But I'm not sure this gets us there, and I'm not saying that. I mean, again, I support the concept. I just don't know whether this language gets us there. Mr. Co-Chairman?
Thank you, Mr. Chairman. I don't disagree with your sentiments, but I can guarantee you that not having a methodology, or at least not working on a methodology, much the same as Wisconsin's doing right now. I guarantee the businesses are not going there. We have an opportunity. I think we've got a problem in the bill, as Mr. Coffin pointed out, Ms. Long. I think we've actually all pointed that out several times now. But it's something that I think we should work on, because I just keep going back to the cowboy coin. I think that representation and what we're doing there, the fear of being regulated on something that is not something that we intended to regulate, and I don't think it's something that the Secretary of State's office intends to regulate, but they do have that obligation now because the legislature has said, look at them all. And so we've got to make sure that they don't have to look at them all when it clearly means, when it clearly is not the intent. It's not our intent to go down that road, go after the cowboy coins and things like that.
Mr. Chairman? Yeah, I don't hesitate to weigh into the argument, but I just want the task force to clearly focus on one issue, and that is the only way to avoid a conflict here between what the Utility Token Act currently says, that they are property, and what this bill attempts to say. I think that language is on 6, so we haven't spent a lot of time, but it is very important, is to exempt from this current bill any coverage of the Utility Token Act. So just to be clear, I mean, this bill not only doesn't address the issue, it clearly exempts that issue. So I think that, that's important.
Mr. Chairman?
Go ahead.
I just wanted to say that this wasn't thought of as just a theoretical. There's already $187,000 records from Teton County in a blockchain that is designed for exactly this purpose. And we were actually just having a conversation yesterday, the next step to that. And there's an enormous amount of interest in doing this, is because it's not that exciting to tokenize the ownership of your home, but if you can add some extra functionality of being able to turn it into an income source by doing so, there's benefit that actually gets on the news and whatnot. So we're very much intending to do this very soon, and obviously if the laws are one thing that's going to hold us back, then that's worth noting.
Go ahead, Mr. Chairman.
Yeah, thank you, Mr. Chairman, and Mr. James. Thank you for bringing that to my attention. We need to work towards possibly Airbnb Mike Yim's apartment for me. I'm in Jackson, so I'll talk to you about that offline.
Good idea. All right, so I'm going to go back to Ian for a second. So Ian, when you're saying that, thank you, Mr. James. With the exemption concept, where we have to make it clear that the digital representation token is exempted, is this as drafted sufficient not to create a conflict, or do we need to strengthen it? If we implemented this right now, would we have a conflict as written?
No, you wouldn't have a conflict. There's no internal conflict in the bill because it just exempts any coverage of utility tokens, which is what you have been addressing. So what you're left with is, in this bill, is no coverage over utility tokens at all. So it doesn't address whether they have to file a $1,000 fee whatsoever. But you then are left with the language at page 6, which talks about property rights. And something that is a much broader issue than anything that has been discussed today. So I mean, I think that's the important thing, is to recognize that if you do pass this, if this were to become legislation, it wouldn't address at all what's been discussed. It would only address what's on page 6. And that is a different issue than what has been discussed, and you need to discuss the breadth of what it does.
So the exemption, as we stated in page 3, that second sentence, which is necessary to create the dichotomy that we needed, makes it clear that utility tokens are in no way otherwise affected by this legislation. So all of the problems we've discussed about utility tokens would be entirely unchanged, not addressed. But we would gain Roman at 4, which clarifies that digital representation tokens shall not constitute real or personal property separate from the rights or interests. So it clarifies that the utility token basically is the ownership right to the thing.
And Mr. Chairman, as I originally indicated, that there is an issue there just in considering, okay, so if you're going to treat everything but the utility token that way, then why are you going to treat those things that aren't utility tokens when there is likely a very substantial overlap, particularly for large utility tokens? You're talking about de minimis ones, but okay, but what about the bigger ones, the bigger ICOs, and how are you going to handle it? So, right?
Mr. Chairman.
Go ahead.
Yeah, and I think to Mr. Shaw's point, and it's a good one, this does not cover a lot of the issues we talked about as a whole separate animal.
Yeah.
Handle, but this does handle, the way I read it, this does handle the situation of setting up a difference between the types of tokens that we don't want to capture as utilitarian. And I think that's an important distinction. Is the language correct? No. Are we going to have to work on it? Yes. But it's a good vehicle. So I still pickup truck.
No, Mr. Chairman, I think it does what it tries to do very well. It's just whether or not we want to do that. And we have a Wayne statute right now to represent real property and tokenize it. We can do that. There is a little difference at that point, because at that point, your digital representation of the property is a digital representation of a corporate entity of some form, whether that's an LLC or a trust. You are representing ownership of that corporate entity, and then the corporate entity owns whatever your real property is. So you have indirect ownership. This is a direct ownership concept where your tokenization of the real property is indicative of ownership of that property, not ownership of something that owns that property. I think it does it well. It's just whether or not we choose to do that. And again, this in no way seems to solve any of our utility token problems, which we just, I think it was did nicely, and we probably need a cleanup bill to fix some of those things, entirely separate cleanup bill, because it's, in my opinion, very different from this. So the question is, do we want that? Do we want, and it sounds like there actually is interest of Mr. Jones and others in having direct ownership represented of real property by a token instead of indirect representation. And it would allow us to, if we proceeded with this, you'd be able to do it either way. It's not like it would screw up the first way. If you wanted a corporation, you could do that. So, with that, is there any more public comment? All right, we've got one more. We do need to get moving on this one way or another because we've got one more topic before lunch, but we're happy to hear your thoughts on it as well. Please introduce yourself and welcome. It's not on yet. You gotta get the little switch at the top and you should see a green light at some point or a red light or something.
John Stokes, Universal Big Project, AI, VR, blockchain. I think there needs to be some language added for tokens that represent ownership of digital property, virtual property that also represents physical property. So, yeah.
Thank you. Any questions? Questions for Mr. Stokes? Seeing none, thank you. I think it would do that because of the way that we define things. Either your property, which we've defined elsewhere in statute, and we've been quite thorough on what is and isn't property with regard to digital assets. So as we're talking about real or personal property, it's going to cover that effectively. We don't have to be explicit on digital because of the statutes that the legislation we passed over the last few years. That's my interpretation, is that it's covered. Does anyone disagree with that or have anything else to add? I would say it's covered. Ian, it seems like we've done a pretty good job of defining what digital assets are qualifying as property and not property.
Mr. Chairman, I think I agree with you. I think that it's broadly written. It's fairly all-inclusive.
Okay. Thank you.
Go ahead. Just another comment or question about the filing fee for for the utility tokens. I think there should be somewhere in there that the fee would be waived for nonprofit initiatives, like creating incentive networks for cleaning up trash in the parks or something, and those tokens could be exchangeable for cowboy coins or something that give people coffee and drinks or things like that.
All right, thank you. That's a good idea. We probably need to take that into consideration. We clearly have to put together another cleanup bill entirely separate from this that will run as a personal bill to try and address some of these concerns about the open blockchain token.
Yeah, because $1,000 is a huge barrier to nonprofit initiatives.
Thank you.
Okay, thanks.
Yeah. Yeah, go ahead as well.
I just realized one additional thing we need to work on, because this actually does affect the Senator Nethercott's SF 125 bill with the UCC clarification. We haven't done the UCC mapping yet here in this bill. So if we do go forward, I think we need to add that to our list of things to do to make sure that there's a direct clarification as to which bucket under the UCC these digital representation tokens would fall into.
UCC clarification.
Yes, thank you.
Yeah, gotcha. Thank you, Ms. Long. Please join us. State your name for the record. Welcome.
Richard Miller. And just concerning the UCC, is there something that's stopping, say, Teton County already from going through the UCC, and I guess it's the Enterprise Technology Services rules at that point, concerning that for the digital recording of the title? It sounds to me in the rules that, especially if the county clerk was on board, but a lot of this is actually directing county clerk who must keep up with the times as far as evolving hardware and software technologies and stuff like that. So I was just wondering what's stopping the digital recording of the title through a county clerk who's on board now. Is there anything stopping?
Can you, real quick before we go to answer, can you spell your last name for us?
M-I-L-L-E-R.
Okay, go ahead, Mr. Butcher.
Yeah, thank you, Mr. Chairman. I don't think anything is stopping that from happening.
But in regards to the county clerks accepting electronic records, absolutely, it says that in statute. That doesn't mean the county clerk is going to want to utilize your technology or X technology. I mean,
Go ahead. It's sort of directed that they must keep up with the changing technologies through the ETS rules.
Mr. Chairman.
You go ahead, Mr. Chairman.
And that's a good point, but that doesn't mean that it has to be your technology that they have to keep up with. So it could be, I mean, I'm just speaking from my own experience. You know, in the corporations committee, we're the ones that pass these bills all the time in regards to electronic records. And I'm here to tell you that there's not going to, unless we specifically and implicitly state use of a certain technology, which I would never advocate for doing, because times do change. There is going to be hesitation from a lot of different clerks there, and that's not to say the clerks aren't doing their best to stay up to date with technology. It's just the clerk's job is a vast and broad aspect, so there's quite a bit there to keep up with. So they can, if you've got a clerk on board, absolutely, this can happen. Doesn't mean that the clerks are going to be on board.
Yes, go ahead, Mr. Miller.
So, my understanding is there is at least one clerk on board in Teton County, and there's information on blockchain, so there's nothing, they're not waiting on the statute to finalize that project.
Correct.
Thank you.
Thank you, sir. Go ahead. Representative.
Thank you, Mr. Chairman. Yeah, just to clarify that, the clerks are basically empowered, and that direction is essentially just a direction, just the direction of moving forward with technology. They're essentially empowered to make their own choices on how to implement that direction. Teton County is pretty good about moving forward in those directions, so again, make the pitch to each of the clerks, but they're not necessarily ordered to do a specific thing in that. It's just a more broad direction of which way to head towards.
Thank you, Representative. Thank you, Mr. Miller. All right, with that, let's close public comment. Back on the bill to the committee. Been all over the place on this one. What's the pleasure of the committee? We have a few options. We can move this bill and pass it at this point in its current form, send it over to the Corporations Committee. That is one option. We can leave the bill on the table and then make a decision. We have a motion. Is there a second? Is there a second?
Second.
We have a motion and a second on 20 also 152.5 digital representation tokens. Committee discussion.
Mr. Chair.
Yes, go ahead, Mr. Chairman.
Thank you, Mr. Chairman. I think that there needs to be some more thought put into this, but I will be voting for it for the continuation of that thought. Whether I show up in my own committee and say, "Hey guys, by the way, we should kill this one," or at least leave that window open. And so that would be my request from the committee: is let's leave this window open and keep moving forward.
Anyone else have any thoughts? Yes.
Mr. Chairman, I don't want to be the stick in the mud. If we want to move this forward for some purpose, I'm okay with that. I just want to understand what the end goal is. Then, are we moving towards authorizing or creating a clear authorization for the tokenization of assets like real property? Is that the lens with which we should look at this, or are we going to use it as a mechanism to do some utility exemption? That's the only clarifier I would ask. Is if we're going to move forward and move it forward today for that purpose, let's be on the same page.
Right. Mr. Chairman, yeah, I think the utility exemption and the utility token issues are a separate animal, and that's sorry, Mr. Shaw, that's a bill we're going to start working on pretty quick because it needs to be handled. But for the tokenization of real property and those types of aspects, I think that's what this bill's vehicle is.
Mr. Kaufman, thoughts? Anyone else thoughts? Representative?
Yeah, personal opinion is this bill is ultimately flawed, and I think there is something that we want to fix in it, but I unfortunately, I don't think I'm going to work to move this forward. I'd rather get it fixed in a way that doesn't necessarily say that this is kind of the structure that we're looking at. I'd rather our groups are over and present it as a personal bill, so I'm really working on this one.
Thank you, Representative. So my inclination at this point, after hearing public comment in particular, is to move this forward. The reason being the difference between a direct representation of ownership rights as opposed to an indirect representation of ownership rights. I can see potential advantage to that, particularly with regard to our real estate, anything along those lines. And honestly, I don't think there's a flaw in the bill. I think the bill does exactly what it sets out to do. So I don't see it as being that bad, but once again, when we get to the legislative session, maybe I'll change my mind. So at this point, I'm going to support it. Any further comments before we go for the vote?
Question.
Question's been called. Please take roll.
Senator Driscoll is excused. Senator Nethercott.
She's obviously here. We'll hold it open for her at the end.
Okay. Representative Olson?
Aye.
Representative Ian?
No.
Mr. Kaufman?
Aye.
Mr. Cole?
Aye.
Ms. Long?
Aye. As restructuring, as restructured, yeah, but yes.
Co-chairman Lindholm?
Aye.
Co-chairman Rothfuss?
Aye.
The motion passes.
All right, and let's hold open Senator Nethercott's vote for her return. Ian, I do think let's take a quick look at it before the Corporations Committee, make sure we don't have to add any language or what language we should add with regard to UCC clarification. Thank you. All right. Committee, the next topic for our consideration is private cryptographic keys. Mr. Co-Chair.
Thank you, Mr. Chairman. If I'm correct, Mr. Shaw, the first thing we need to do is have a motion to, what's the word I'm looking for? Move to reconsider that legislation. Move to reconsider that legislation.
One moment on that. So reconsideration motion puts the piece of legislation back in its original state prior to vote without a possibility for amendment. So that's not what we want to do.
Mr. Chairman, that is correct. Although you can, there's a couple of ways to handle that. And committees have handled it in various different ways. Right, if you do, Mr. Chairman, you are correct. If you do a motion to consider, it just puts the final motion before the committee. And it's not a debatable motion either. So you would go to that stage. You can fail that motion, however, in which case the vote would then be to deny the motion to sponsor the bill the first time. You can amend the bill and then have a motion to sponsor it as amended. Whether that works on the floor every time, it would be up to the chairman's prerogative. That's how committees have handled it in the past.
All right. Ready for that?
So we do need a motion.
We need a motion yes, Mr. Chairman, we need a motion to reconsider. So we need to pass the motion to reconsider. And then once we pass the motion to reconsider,
we got to kill the bill.
We have to kill the bill. So we all vote no.
So vote yes, then vote no.
Then we put the bill back on the table, basically.
Yep.
And then we can talk about it in a minute. Everyone good with that? Everyone sure that?
I move to reconsider.
We've got a motion and a second for reconsideration. This is not debatable. Please call the roll.
Senator Driscoll is excused. Senator Nethercott is excused. Absent. Okay. Representative Olson.
Excuse. It's fine. It's a majority of the present.
Representative Ian.
Yes.
Mr. Kaufman.
Aye.
Mr. Cole. Ms. Long.
Aye.
Co-chairman Lindholm.
Aye.
Co-chairman Rothfuss.
Aye.
Okay, the motion does pass.
All right. So we are back on the question.
Mr. Chairman, I call the question.
All right. Roll call on 20 LSO 163.
Right, so Mr. Chairman, this would be the original, brings back to the motion from last meeting on whether or not want it to pass as amended at that point. Senator Driscoll is excused. Senator Nethercott
Also excused.
Representative Olson.
Excused.
Representative Bien.
No.
Mr. Hoffman.
No.
Mr. Cole.
Nope.
Ms. Long.
No.
Co-Chairman Lindo.
No.
Co-Chairman Rothfuss.
No. All right, that's a dead bill. Put it back on the table. Chairman. Yes, Mr. Co-Chairman.
Do I need to make a motion to put that back on the table, or for us to actually?
We've got it on the agenda, we got it actually noticed on the agenda as a new working draft of that bill, so it doesn't have to be a motion.
Perfect.
We can now consider, welcome back, Representative. We did some things. All right, welcome back, Senator. Senator, you have an open vote on. Not necessarily that one, but that's a good vote. It's both a vote. Digital representation tokens as drafted, no amendment. Are you and I or no?
No.
Okay. Please record Senator Nethercott's no vote on 20 LSO 152 digital representation tokens. It passed. Otherwise. Good. She needed it. Good company. All right, so we are on 20 LSO 163, now version 4, private cryptographic keys. Wherever it went. Staff, do you want to talk through a little bit about what consideration is? We actually talked about it.
Yes, Mr.
A little bit during the break. Please go ahead for those who get more present.
Mr. Chairman, so this bill originally passed in Form UC in 163 version 4. There were actually some small changes to the bill at that point on page 5, lines 7 through 11, sort of the key language. We did take out the interest about, there were we took out some language in that paragraph, just cleaned it up generally. However, at that time, there was a discussion during that meeting about what the original intent of the bill was. As drafted, the language on page 5 is fairly broad. During the meeting, the task force discussed in a fair amount of length the purpose of the bill and the real, and at that time it seemed that the purpose was fairly targeted at whether or not there should ever be a production of private keys. And according to that discussion, and that was more of a targeted discussion at the main meeting where, at least for LSO, I think it was a broader purpose was available, but I think that the LSO was perhaps a little confused about what exactly had to happen. So after we passed that bill, I drafted potential language that you will see on I think it's available on the counter over there, and each of you have had on your chair. So the potential amendment to 20 LSO 163.4 private cryptographic keys. There are two options. This language is intended to much more specifically target the production of private keys. And it's taken from some similar language other places in Wyoming law that, of course, don't deal with private keys or digital assets, but that provide what I think is intended to be a complete prohibition through any government action that would require the production of a private key. And I think this language is important and has two very separate elements. The first element of the language, and by the way, on this sheet that we have, option 1 and option 2 actually are identical language. They're just placed in two different places in the statute, so there's no difference in language. As I said, the language has two different parts. The first is intended to be a prohibition against the publication or the production for any reason of a private key. The second sentence in that is tries to make clear that that in no way prohibits the production of any information about those assets or other rights to which the key provides access. And so the attempted language is an attempt to be very, very narrow. You never have to produce your key, but you can be forced to produce anything about the assets that key provides access under the normal circumstances. It's not saying you necessarily have to do that, but it leaves that option open for a court process, a legislative process, etc. So again, the amendment is intended to more clearly address the committee's specific discussion during its last meeting. I would note, if I talked to some of the task force members about this, I think there are two important things for the task force to consider. First of all, in the bill, on page 3, lines 13 and 14, we define what a private key is. And that's from an existing definition in our digital asset statutes in section 103. So we define what a key is. I think for purposes of this amendment, it's important that the task force is comfortable with that definition. So if we're going to provide an absolute prohibition against its production, then you need to be comfortable with the definition is. The second of all, as I already said, the second half of that amendment attempts to say, to make an airtight distinction that while you never have to produce the private key, that never means you don't have to produce information about the underlying assets. Mr. Chairman, if there are other questions, that's the amendment that LSO has drafted. Otherwise, I don't need to suggest that the committee or the task force has otherwise approved that amendment. It's just for your consideration.
Thank you. All right, committee. Any discussion before we go to testimony yet?
Thank you, Mr. Chairman. I just want to ask the committee because I believe this was the day that I was stuck in transit that I missed the discussion over it. And seeing that we used the reconsideration motion, it means that it failed during the time I wasn't here. So I'm curious to hear what the arguments for and against it and why it did fail. If maybe the chairman could on what this like.
Representative, can you restate that question? What failed?
Because on August 19th, the August 19th meeting, when I wasn't here, there was either there was no motion or we did a reconsideration motion, meaning there was a motion that had failed, right?
No, Representative, we passed this bill as written, and then there were concerns.
I see. Okay.
So the reconsideration we just did was to bring it back on the table so that we could address the concerns that we got.
Mr. Chairman, and I think to that point, so that when we voted in August, we had moved that bill forward to the next step. And afterwards, we found out that we had some screw-ups that we needed to fix. That's why we just pulled that bad boy back. And that's the two-step that we had to do.
And Mr. President, it might not even be a screw-up. Honestly, I still support this bill. But we have an entirely different approach on the table that was raised that needs to be considered. Ms. Long.
Mr. Chairman, I want to give a special shout out to Chris Allen and Jason Coons who had a debate about this, and it was Jason who was watching the live stream and said, well, wait a minute, you haven't thought about the theft of a private key, because if you say the private key is not property and someone steals the private key, is that a crime? He raised that very interesting question, and that's what I think, that is why we needed Representative Yen to go back and reopen it. It was something we just overlooked. And I'm very grateful to the community who is watching and helping us, whether in person or online. Thank you for helping us make better bills.
Thank you, Ms. Long. That is exactly right. So that's why we have this back with that potential concern is that by indicating that it's not property, we don't give it any protection. All right, further discussion we have this proposed language. We can go to public comment at this point in time. Does the committee have anything else to discuss prior to public comment? I see none. Public comment. So we're basically addressing this proposed amendment to this bill, and what we're really looking for is his thoughts on which approach is better. Why does this alternative language, which precludes compulsion of the private key, work sufficiently, and what are your thoughts? So, with that, welcome once again, Mr. Allen. Please introduce yourself for the record.
Yes, Christopher Allen, Blockchain Commons. Again, Mr. Chairman, Task Force Committee, thank you very much for your work in the past understanding it and continuing to bring it forward. I do believe this is a lot more important than you might realize. And it comes to a fundamental difference between digital world and a physical world, where the illusions of similarities and metaphors and whatever are fine, but they break. So we have this tendency to have this word key we have in our minds. Oh, this is like a key to a safe deposit box or a key to my house. And that's not exactly the way they work in the digital world, especially in a secure way. The most important thing here is that there is no safe way to transfer or share private keys. As cryptographers, as security engineers, everything, we're doing everything we can to make it as locked down, as hard to transfer, etc., and instead use properties that are derived from that private key, such as public keys and other different types of things, to actually do the work. When they are no longer secret or guessable because of errors and things of that nature, that is what makes for significant security risks, for ourselves as individuals, as organizations that rely on these keys, as we increasingly do stuff in the digital world. So I think that there are a couple of different complications here that we talked about in our conversations. Especially, I'm sorry, what's the gentleman's name who was who commented last?
Through the chair, go ahead.
It was Jason Coombs.
Yes, Jason Coombs has had a lot of different, I think, very good arguments based on Supreme Court case law, et cetera, of sending a very strong message about civil liberties and things of that nature, connecting it to the Fifth Amendment, connecting it to some recent Supreme Court cases. I would love to go down that alley, but I don't think it's warranted in this particular case. I think we can make a really firm, clear line here with what we have. I like the amendment that the LSO proposed. I welcome a conversation about striking maybe one word with Senator Nethercott and et cetera. But the key thing is, back to the technology, we can't change the reality that it is fundamentally different, and protection of keys, we're doing everything. Right now, I'm working on projects so we don't even attach it with a wire. No Wi-Fi, no network, no physical access to the key, and we're using things like QR codes and AirCap and all this type of stuff, so that we're really trying to protect that private key as carefully as we can.
Thank you, Mr. Allen. Any questions, Mr. Allen? Yes, Representative.
Thank you, Mr. Chairman. Mr. Allen, what would happen if you lose control of your private key, not necessarily through anything in this amendment, but in real life to another person? What would your actions be?
Go ahead, Mr. Allen.
Yes. So first off, you have to know that there's been a loss, which I talked about in the smart custody book. There have been a number of cases in the past where an important private key was stolen, wasn't actively used, was traded on the black market, repeated number of times over the course of a year or more, until I got to the ultimate buyer of that secret, who then used it in a way that was harmful to the exclusive control that the secret holder had in the first place. So there have been numerous instances of that type of harm. In the case of an individual, not only, the easiest things to take are your exclusive cryptocurrency capabilities. That's the Bitcoin, Ethereum, things of that nature. All of the assets that you're holding under a single one of those keys.
Yeah, Mr. Chairman, thank you. Just to clarify, what would be the actions that you would take if your key was taken and you knew immediately?
If I knew immediately, I would try, it would be a race between me and my adversary as to who first could move them over to a new secret. And since I may not know very quickly, in fact, I may not know until the thief has actually done those actions, I may not be able to stop them from happening. Yes, different things like I didn't get to identity is another thing that's secured with these keys. I could revoke my key and issue new keys, new secrets. And again, there's a race between the adversary and yourself. And the adversary has an advantage because they know that they have it and you don't.
Representative Paul?
Thank you, Mr. Chairman. Yeah, so to follow up, so you said that regarding your digital identity, you could revoke the key and create new signatures. So then my concern with this amendment is why, if you know that the court, for some reason, I don't know what reason that would be, but let's assume that they had a reason, would compel them to make this private key known to the court or whatever, what loss is there if I can just revoke the key and create a new signature?
The problem is now
Mr. Allen, go ahead.
I'm sorry. The problem is now they ask for that new key because it's they're asking for all private keys associated with the thing. Moving your assets, your things to a new key doesn't mean that they still aren't requestable by the court. The point from a cryptographic point of view is that with the public keys, the court can get everything that they need to be able to compel the individual. Now, if as in some recent cases where somebody has refused to share the public keys, there are other actions that the court can take to compel that individual to do the transfers or to make the public key available. But the private keys is where the problem is. So again, when we're talking about civil law and damages and things of that nature, if the assets, the capabilities for those are control is held by the private key, you should compel the transfer of the assets. If the court says we can't trust you to do the right thing with these, we're going to appoint an intermediary to hold them until the court makes their judgment. The court can do those types of things, but that case, the mediator, the holder, the third party will have their own set of private keys and proper due diligence of those private keys, and it's simply passed to the control of those keys, not, you don't hand your private keys over to someone else. You transfer it to someone else's private keys.
Paul, Representative? Thank you. Any additional questions? Seeing none, thank you, Mr. Allen. Any other public testimony at this time? Come on up. Welcome, sitting in for the committee, and who you're with.
Unchained Capital from Austin, Texas. Our business facilitates traditional asset-backed lending. We take Bitcoin as collateral, and we help people secure their Bitcoin, and we do it in a way where we only hold a certain number of keys in a quorum. So in certain multi-sig Bitcoin contracts, we'll hold one key, our clients will hold two, or we'll hold one key, our client will hold one key, and another institution will hold a third. One of my questions about this amendment says, the private key shall not constitute a digital asset or interest separate from the asset. And in many instances, we actually will use the same key or a derivation of the same key to protect assets that are controlled by multiple clients. or multiple pieces of collateral that back loans. And so one of the things that Christopher Allen and I talked about is this issue of compelling private keys. In our case, if our single key or derivations of a single key are protecting unique assets of multiple clients or multiple addresses, that if we were ever compelled to produce a private key, the consequences could be far-ranging. And so, that is probably one comment where I would have a question, because in our view, a private key and the asset are distinct, because a private key could control multiple different assets. So that's one comment that I would make for the committee to consider. On the other side, though, on the other side of the fence, which I don't know if there's a distinction, but there may be an instance where there could be a judgment in a court to compel somebody to use a private key to, say, transfer an asset rather than to produce it. And whether somebody wasn't I guess following a court order to compel the use of a private key. Say if we have a loan and there's collateral and we need a key to be used by a client to move that asset, we don't necessarily need access to the private key, but we would need potentially a court to compel someone to use a private key. So just drawing that distinction as well. Not necessarily a question, just wanted to raise those type of issues that we deal with every day.
So I think this is good to reiterate. So your thought there is it's fine to compel use of a private key, no real concern. Probably also fine, we discussed offline a while ago, to compel proof of ownership of a private key.
Right.
But not the private key, so. And one of the concerns that you have from your use case for private keys is the multi-use operation that you have, where you are a co-signer, and you might be using the same key to co-sign, we'll say 100 different accounts, and it would provide a security vulnerability that would be very challenging to repair under any circumstance at that point.
Yes, correct.
Is there anyone that you would trust with that key?
The challenge is the circumstance in which it would be compelled, and that if that key was shared with any other party, we would always operate under the assumption that it could no longer be trusted, and would then need to securely transfer any other assets that are secured by that key to a new quorum of keys that don't include that key that has been exposed. So I think that's a short answer to say no, just by the mere nature of the disclosure of it.
If, going back to Representative Ian's question a few minutes ago, if you were required right now under statute by a judge to disclose your private key, and that's a multi-sig that's used by 100 different companies, tell me how that would play out. So you comply, you give them the key. What's your next step?
I would think that prior to any disclosure, we would move any assets that were unrelated to the private key, unrelated to the dispute at hand. We would move those assets to a new quorum of keys secured by a different private key prior to disclosing that. The challenge is that we structure our business with an incredible amount of security around a few number of keys, and so from a business instruction standpoint, kind of going through that process of creating a new key and going through the kind of a key signing ceremony, or kind of decommissioning an old key, creating a new key does create disruption, but we would certainly do that prior to any disclosure. Otherwise, we would be left in a situation where we disclose something related to a particular asset that puts likely orders of magnitude of greater amount of assets at risk as a consequence.
Sure. 1 second. Senator Nethercott, would like to follow up on that? Go ahead, Senator.
Thank you. I really appreciate those common sense responses and answers to how you would navigate a situation if you find yourself being compelled by a court order to do that. Kind of note, and just to consider in light of your business model. So, what I understand, you hold keys for others, private keys for others. to where they have their Bitcoin behind that key?
Go ahead.
The way that I would think about it is that we secure our own key, and our key helps secure our client's assets. So it's not necessarily the client's key, it is our key, but that key contributes, and we have contractual relationships through our clients and obligations, and it shares in the security of client assets.
So I'm just going to follow up for a question for purposes of illustration.
Absolutely.
So can your clients access their assets but for the private key?
Go ahead.
So it depends. In certain instances, if our clients hold, say, 2 of 3 private keys, or we only hold one, there's nothing that we could ever do to move funds, and that our clients could always move funds without with us having to do anything. In other circumstances where a client say only has 1 of 3 keys and insufficient keys to move funds, they would need some coordination or collaboration from a second or third party.
Okay. Mr. Allen?
So I think that last point is very important. In his business model, they don't control the user's private keys. They also don't control the assets. They help secure the assets. So yes, it is theoretically possible to contact every single asset holder as a client of the company, but that may take time. Some of those parties then have to contact a third party. In more sophisticated situations, and they have to contact a 4th or 5th party. So, all of those people have to coordinate and move their assets onto new sets of keys in their own situation. So now you're basically demanding maybe, I don't know how many
Like currently
hundreds of clients to basically, they also have to redo their keys. So it ends up being this, mess where they're having to coordinate 100 other people to have to regenerate their keys, all because one customer is being forced to compel to reveal a private key, when in fact you can just tell that customer you must move your assets to another account, which is very secure. We have ways of doing that safely.
Yeah, and one thing that I would ask, I think, to Senator Nethercott's question, or maybe at the root of it, is, say we were compelled to produce a private key, and amending my prior answer where it would say what we would do in an ideal scenario is facilitate the commissioning of a new key and move any funds secured by the old key to new keys before we disclose it. To Christopher Allen's point, in many cases, we can't necessarily compel our other customers to coordinate with us in a certain timeline to facilitate movement, because in many instances, we only hold 1 of 3 keys and are not in a position to unilaterally move funds, which presents a challenge that, say, if we were required by a certain date to provide access to a certain key, there's no assurance that we would be able to move all funds secured by that key to another key prior to any deadline, which creates ultimate risk for other clients.
Thank you, Mr. Lewis. Ms. Long.
Mr. Chairman, may I ask the presenters, what is the cost of a private key ceremony? And if you were compelled to give up the private key, how do you think about the reality that means future forks and airdrops would no longer be claimable by you because you had to move your assets to a new private key, so you're leaving value on the table as a result?
Okay. Would either of you like to field that, Mr. Lewis?
So it's difficult to estimate the cost of decommissioning a key and recommissioning one, because a lot of the cost is related to coordinating all of the activity with all of your clients. So that's really where the true operational costs would come in, less so in terms of the kind of tangible or identifiable cost associated with new hardware and getting resources together. It would be more on a practical basis, the movement of all client funds, which would take weeks and likely weeks potentially. It may not be possible to secure all funds, so that would be. And then on the question of the forks, if we ever decommission a key, we always keep a key. I think the risk would be, so we could always go back to an old key to access forks if we need to, but the same thing would hold true that if a key was exposed, then it's still, the assets are still at risk.
Mr. Allen, is that anything?
Yeah, I mean, so, again, you know, at the least expensive level as far as best practices, you know, of an individual, it's on the order of, you know, a day to several days of work and such. But when we start talking about people who are shareholders, officers, involved with other organizations, you know, people of that nature, a much higher threshold. Whereas the best practices of an organization, although they're not trying to do the same kind of custodial, regulatory type stuff that you set forth in your own requirements for custodians, it is darn close. You're basically saying that entire long document that you've done and all the processes that are necessary to secure that request, they're going to be having to do if it ends up resulting in a key that has to be compelled. And again, for at least under civil law, the court can get everything they need, how much money there is, who controls it, you know, all that type of stuff from the public key. So you're putting at risk and putting a lot more people involved by having the disclosure of the private key.
Is there any scenario where you would need the private key instead of compulsion, the things we discussed, compulsion of proof, compulsion of use? Is there any reason a court would ever need to actually see a private key? Some additional advantage of proof, some additional piece of evidence that that private key could represent that you couldn't get from an alternative scenario as you laid out?
So, in my opinion, no. There is no advantage because either way, you know, if you're concealing assets, you're going to conceal anyhow, not even admit that there's a private key and a public key. You're in the same boat either way. But if you're going to admit that there are assets and that there is a private key, you can do everything that you need with a public key. Now, that, you know, having one of those private keys is not going to help you discover any of the others. Are all independent. So. You know, somebody's going to lie in court and conceal. They're going to lie, and having a public key, I mean, having a private key isn't going to help.
And I would just say on the distinction between compelling use of a key versus the disclosure of a key, the only scenario where I could envision there being a difference or kind of a challenge there is if there's a judgment against, say, a client of ours and via court order we're compelled to use our key, and for some reason we are ignoring a court order, a valid court order, and the physical location of the key was known, that would be the only scenario where I could see a distinction between the compulsion of using a key versus actually providing the key itself, where if somebody was uncooperative with the court order, then you need to go to the level of, okay, now if you're not going to use, if I'm compelling you to use the key, but I know where it physically is, and you're not complying, then I'm going to need to actually physically take the key so that I can use it.
Go ahead, Mr. Allen.
And in that case, the court has other remedies. You know, we have the ability to put somebody in jail. We have the ability to, strike their ability to do, a variety of different other actions. So there's lots of other recourse that is safer than the use of private key.
And that assumes that there is a physical cold storage hard copy of key. There doesn't have to be the case, although that is a common best practice. Is that accurate?
Correct.
Mr. Chairman?
Yes, Mr. Paul.
I was going to say, there's one other scenario, I was going to see if y'all agree on this, but I think it keeps in the spirit of what we're saying, that you never need the private key, is the public key can prove the underlying assets, but even if they wanted to compel you to prove that you're the owner of a private key, you can do that through signatures and ways not disclosing the private key, right?
Mr. Allen?
Yes, but again, it's, if you're not consenting to something despite the court order, you're not consenting. I mean, it's, all kinds of ways you can obscure just simply saying that, oh, that's not
Also, yeah.
Mr. Lewis, go ahead.
No, I was just going to agree with that would be another mechanism. You could create a signature to prove ownership of the private key. If for some reason that was deemed to be more
necessary rather than just provide a public key without disclosing the actual private key.
Thank you. Any additional discussion? Paul, you good? Committee, additional questions for Mr. Lewis?
Mr. Chairman?
Yeah.
I didn't even go into any clarification. I thought of the circumstance. It was indicated that one potential option, if you're required to disclose a key, would be to move those assets that aren't involved into a different location under a different private key. My only concern might be something like a bankruptcy, for example, and when in a simple situation where it's a single account or it's controlled by a single private key, you're moving assets out of that account might subject that person to charges by the court that they're making decisions about which assets they're moving. So it could be problematic. Senator Nethercott, go ahead.
Mr. Chairman. Thank you. I think right now, a court could compel a private key. In the event that your company was subject to that kind of a court order, I believe the pathway that you provided is proper. You would work with your counsel, you would work with opposing counsel, and you would work with the court on identifying ways to avoid turning over the private key and instead providing the necessary information. I think what the testimony was that I heard was you would remove all assets unrelated to the client at hand who was subject to the bankruptcy or to the judgment. And you would probably need to get court permission to do that to make sure it didn't look like assets were being offloaded that belong to the client. But there are clear ways to do this that happen all the time. I am concerned that we are dictating to a court and to litigants what they can and cannot have in order to have a fair and just controversy, which is the fundamental piece. These are questions that courts answer all the time. And I understand the concern that they don't understand the private key in the same way that we're all, or at least I am struggling to understand all of the applications for the private key and the public key, but I trust that they have the capacity to make the right choices, balancing interests. I just want to recognize that there is complex litigation going on all the time concerning trade secrets, chemical formulas, national secrets. I mean, very, very, very important information for which the courts have the ability to put parameters on that usage and use it appropriately and carefully. There's major federal investigations going on all the time involving major state secrets and terrorist organizations, and we're able to handle pretty complex, important pieces of information. So I just want to make a clarity that without this protection now, yes, I hear it's a major inconvenience. And maybe business practices need to change as a result of that inconvenience. It is inconvenient to go to court, be litigated against, have to compel documents. It is a nightmare. And also how to manage your business practices. And if it's not a good idea to have that limited amount of private keys, I have no idea. It seems to me it's not a best practice. What I've also heard is kind of all your eggs are in one basket behind this one private key. Legal advice would be don't do that, right? It seems like there's too much at stake with this one private key, and the exposure of that one private key, whether it be through a private action or through a judicial action, is of great risk. Don't do it, right? And those are my thoughts. So I'm just very hesitant to dictate to the court now without having facts in front of it what litigants, not the judge, not the courts, not the government, not the bank, but litigants, people going to court for a resolution can and can't have.
Yeah. Start with Ms. Lewis, go ahead.
Yeah, so my only comment to that would be, one of the primary reasons why, say for every client we don't have a new private key is because, as Christopher Allen's talked about, a lot goes into the physical security of every key, and then the social construct in terms of how we access that key, such that if we were managing hundreds, if not thousands, of private keys for each potential client, that would become operationally impractical and actually create risk for everyone. So there's just the idea being we don't have a single key, but we don't have a key for every client. We find a balance between there. So just kind of clarifying on that point. And then on the other side, I'm not necessarily saying that you should restrict a court's ability to, in any case, kind of not necessarily, this language would certainly be advantageous to us, and I think would be productive for us. But the point that I'm just making, I think this is the point that you made, Senator Nethercott, was that there may be unintended consequences, and these things are very dense and confusing. And if a judge compels someone to do something that, without understanding the far-ranging consequences, that would present serious consequences. But I presume in those scenarios, our counsel and opposing counsel would work to educate the judge and work toward a goal that said, what are you really trying to get at? Because I think we can give you what you're trying to get without, giving you what you just asked for.
Right, sure.
Yeah, so, these, especially these more important, multi-sig keys are, tens, if not hundreds of thousands of dollars worth of operational experience. You're putting a big burden on every, sort of prosecuting attorney that's involved in this. You're basically saying you, in order to do this stuff safely, ought to do something on the order of that, order of magnitude of your keys. And you're also putting that burden on the court to be able to be fair and prudent and less risky to have that level of security for each of those keys that are being held by them is a big burden. It also makes for a big attack surface. It basically says, oh, well, I'm just going to pursue, these companies that are litigating this type of stuff. Now, I am up in, I think it is a reasonable thing, like in the amendment thing, where it says, any civil, criminal, administrative, legislative, or other proceeding to strike criminal. I'm willing, she was saying, yes, we do things with terrorist secrets and things of that nature that are very, very high things where maybe we want to do things in that category. My biggest concern is that, usually courts basically, in effect delegate down to attorney firms to do the discovery, to do a lot of the different aspects of these types of things, and have them with tremendous expertise in law and all that stuff also have to have sort of our level of expertise, proper care of private keys. Feels like a really scary move, and is a risk not only to the individuals but potentially to the larger community.
Thank you, Mr. Allen. Do you have any follow-up you want right now, Senator or Representative?
Thank you, Mr. Chairman. So, for example, I think I'm going to go to the one situation where you said it should be reasonable to. You can't see the situation where someone compels the private keys, not necessarily reasonable or not, but if I am getting a divorce and my spouse, and the court has decided that I get control of my spouse's crypto assets, and my spouse decides they'll just be in contempt of court, and never turns over the assets, am I just supposed to accept that loss? Even if we strike criminal, that's still civil action, right? So, do I get hurt because of this amendment?
So,
Mr. Allen, go ahead.
So my take on it is the right response is if somebody is basically not just violating, the contractual relations between me and my ex-partner, but instead they're violating that of the court's proper judgment in this particular case. They have lots of things that they can do. They can put, contempt of court. They can, ask for damages from my salary. They can do all different kinds of compensation. It's the specific performance that has, of producing the key in civil actions that has me concerned. I think there are lots of other ways you can, either through damages or through contempt type of stuff to get the things you do. And ultimately, you still make, even in situations where that aren't going to have anything to do with digital assets, these things still happen, and people do, spend a year in jail to prove their point to their spouse. The This isn't any different. Those things will happen, but they're part of, the way things work.
All right, we're at 12:20 right now. It's a little bit after when we're aiming for lunch. I'm going to ask at this point, who else would like to provide public testimony on this topic? Is there anyone else intending to provide public testimony on this topic? All right, seeing none there. Let's see, are there any further questions? My idea is probably going to be, if Mr. Co-Chairman agrees, to conclude public testimony before lunch and then come back after lunch and work the bill. All right, any further questions before we close public comment? Thank you both very much. We really appreciate your participation. With that,